Switch off
Lordship.
on karo. Light. Yes.
Lordship, I crave leave to move this application for clarification of order dated 3rd November, Lordship.
I can't follow what?
Lordship, I crave leave to move this application for clarification of order dated 3rd November in WPF.
Passed by whom?
Order passed by your Lordship. This was a matter in that which was granted leave from you, Lordship. This was from the determination of Justice Vishwajit Bosu. The petitioner duly in compliance of your order dated 3rd November, Lordship. The petitioner appeared in the examination, Lordship, and he has successfully passed. But the university is saying that there is no clear averment in the order that non-imposition of an year lag. There is no clear averment in the order regarding non-imposition of year lag, Lordship. So
non-imposition of
year lag, Lordship. Year lag.
Year line.
Year lag, Lordship.
Achha.
Lordship, the university is publishing the result.
So mention before the regular bench.
Lordship, this is your order, Lordship.
So what?
Lordship.
Mention before the regular bench.
Lordship, may I mention CS com number 451?
Take microphone, be louder.
May I mention CS com number 451 of 2024? May I mention CS com number 451 of 2024? I'm mentioning for inclusion in the list. There was an
hearing of suit.
Your Lordship, there was an Order 7 Rule 11 which got dismissed by Honorable Justice Krishna Rao. Thereafter, the matter went out of the list. I'm mentioning for inclusion.
Mention after January. Next. Ashu. Dakun.
Bank of India. Yes, I appear for the plaintiffs, my lords.
এই এটা সরিয়ে রাখো বাবা। Yes. এটা আমরা কারেকশন করব তাই তো?
Yes, my lords.
The date.
Order is dated 6 November 2025, my lords. May I hand over to you?
What is the correction?
It's on page 3. It is on page 3.
November 3, 2025.
It should be, yes, my lords.
The matter appears under the heading to be mentioned for correcting an apparent typographical mistake in paragraph 5 of the judgment and order dated November 6, 2025. The date mentioned as November 3, 2024. November 3, 2024 should be read and corrected as November 3, 2025. When the written statement was affirmed by and or on behalf of defendant number 5 to 15. That's right? Poster. Paragraph. Mr.
Shubham Raj, my lords. Shubham Raj.
Suman?
Shubham Raj, my lords.
Shubham Raj, learned counsel, advocate, appears for the plaintiff. Paragraph. None appears for the respondents. Paragraph. The said correction, the above correction shall be incorporated in the judgment and order dated November 6, 2025.
Publishments.
Full stop. Today's order shall be treated and part and parcel of the said judgment. Shall.
For the defendant number 1, 2, and 5.
My lord, I'm appearing for the plaintiff. I'm being led by Mr. Choyan Gupta, who is appearing online.
All right.
My lord,
Two.
And I am on behalf of defendant number 3.
Who is for the plaintiff? Whose application?
My lord, it's
appear
my
for the
application.
plaintiff,
I'm
my
for
lord.
the plaintiff. I'm being led by Mr. Choyan Gupta. He's
My lord,
online.
What is the application for?
My lord,
My lord,
GA6 is an application
application
for substituted service. My lord, I think my learned friends are appearing for a few defendants, and we have served this to them already.
All
If they
right.
could waive the service.
Wait. Kunta Ashini. The paper is not there for item number 2.
My lord, 2 was
But-
went out of the list. Item number 2, GA1 was out of list at the instance of the plaintiff on 15th of December 2020.
Give me the order.
My lord, it's mobile.
Sir, I am not going to see your phone. It's your personal device.
My lord, not printed, my lord. It is an order dated 15th of December 2020.
Yashish.
I am
2, 3 and
Uh,
serial number.
number two.
my lord, if your lordship kindly takes up item 3 once. Item 3 is my application.
A short question, sir. What are the connected serial numbers today appearing in the list?
2 and 3.
Item 2 and item 3. Item 2 is
2 and
2
3.
and 3.
Acha. So 2 and 3 একটাই order হবে. Mr. Choyan Gupta, Learned Counsel, appears for the plaintiff through virtual mode. Paragraph, Mr.
Omortho Boshu, appear on
Omortho Boshu, Learned Advocate, appears for
defendant number 3. Defendant number 3.
3. কাগজটা কি পাবো ভাই? Mr.
Arnab Mukherjee.
Arnab
the
Mukherjee,
defendant
Learned Advocate, appears for defendant
1,
numbers
2 and 5.
1, 2 and 5. Paragraph. None appears for defendant number 4 and 6. Mr.
Arnab Mukherjee.
Arnab Mukherjee, Learned Advocate, appearing for defendant number
1, 2, 5.
1, 2 and 5. TO2 or 1, 2?
1, 2. 2.
1, 2 and 5 submits that by an order dated
16th December 2020, passed by Honorable Justice
2020.
2020 2020. Renumbered, my lord. It was initially old number was there. 19
By an order dated December 16, 2020,
15 December,
December 15, 2020,
passed by Honorable Justice Devanshu Bosak. Ordering portion is, my lord, the learned advocate of the appearing for the plaintiff submits that the plaintiff are negotiating with the principal dependents for settlement. In such circumstances, GA 1 of 19 will be out of this list with liberty to mention.
IAGA 1
of 19.
of 2019 was directed to be was directed to go out of the list with comma with liberty to mention. Full stop. Now, Mr. Choyan Gupta, what is your application? I can't hear you.
My lord, my application is for substituted service.
Which
My
one?
lord, item 3, which is IAGA number 6.
Wait. Next লিখো ওখানে তলায় IAGA number 6 of 2025. একটু কাগজ দাও বাবা এইটা ঠিক আছে wait. This is an application filed by the plaintiff praying for substituted service of writ of summons upon the defendants. paragraph. Since
1, 2, and 5.
defendant number 1, 2, and 5 have already been represented, and defendant number 3 has already been represented. ওটা have, এটা has. ঠিক আছে, plural আছে. There shall be an order for substituted service upon defendant numbers.
My lord, now 4 and 6 remain, my lord.
Defendant number 4 and 6. Full stop. Paragraph. Appropriate publication shall be made once in Telegraph and once in.
My lord, only one humble submission subject to my lord's kind consideration. Kindly seize the cost title. The defendant number 4 is in Ernakulam. So, my lord, perhaps, my lord, an English newspaper having wide circulation in that area should possibly, my lord, subject to my lord.
Once in Times of India, All India publication. Once.
Could I humbly suggest one thing? A newspaper having wide circulation in Ernakulam and a newspaper having wide circulation in Ernakulam, but I do not know, my lord. We'll find out, my lord. And for defendant number 6, they are in Kolkata within the original site. So, my lord, whichever your lordship deems fit and proper.
Once in a newspaper which is widely circulated at Ernakulam, local newspaper widely circulated in Ernakulam, once in Times of India, All India publication, and once in Bortoman. Full stop. The publication shall be caused within 3 weeks from date by mentioning the returnable date and gist of the case in the plenth. Full stop. Paragraph. The plaintiff shall file an affidavit of service when the matter shall be made returnable on the next day. Paragraph. The matter shall appear under the heading New Motion on December 19. No, sorry. December 17, 2025.
Could I pray for one more indulgence, my lord? If you serve, my lord, the plaintiff in course of the day, my lord. Otherwise, my lord, in the sheriff's report there is no service and they just only appear.
Yeah,
So
I can't.
But if your lordship records, my lord, that the appearing defendants waive service of the summons.
Your lordship, we have actually not received the summons. I was about to say.
No, waive service of the summons. We shall serve the plaintiff in the course of the day.
The appearing defendants have waived service of writ of summons since they have already.
So grateful. I'm so grateful.
And the plaintiff shall serve all the cause papers and the orders passed so far in the proceeding upon the appearing defendants.
I'm grateful. We shall do that.
And file affidavit of service on the next day.
Grateful, Your Lordship.
Along with the and shall incorporate the same in the affidavit of service.
Extremely obliged, my lord. Extremely obliged.
Thank you.
Grateful.
Correct, my lord.
Malad, in item number 4, I'm appearing and representing the defendant. My GA number 4 is there, my lord.
I appear for the plaintiff, my lord, in this matter. My lord, GA4, my lord, item number 4 and item number 30, my lord, are connected matters.
30.
30, my lord.
Look at Mr. Dutt, what to do. 4 and 30 are connected.
My lord, item number 30 is an application that has been preferred.
Application 30 is an adjourn motion. 4 is a new chamber.
My lord, GA4 had already come up, my lord, on the last occasion. It's in any case, my lord, has come up now. My lord, GA4 has been filed by my other side, my lord. They have prayed for return of the plaint, my lord. We seek an extension of time to file our opposition, my lord.
Look at the situation, precarious situation I am in.
Malad, if permit, can I say something, my lord?
Yes, yes.
Okay, my lord. This is a suit for seeking refund of 10 lakh rupees as advance paid to us.
Don't submit on merit. You tell me.
No, I'm not on the merit. I'm only making an offer that if even though machines are ready, if they are willing to I'm willing to refund their advance payment of rupees 10 lakh.
Let me see the prayer in the plaint.
My lord, it will be very nice, my lord. My lord, the prayer is.
Let me see. Where do I get the prayer?
Internal page 8. Page 14 of GA4.
Come on, take the microphone, madam.
Page 14 of GA4, the prayers are set out, your lordship, and it's at page 8 of the plaint.
GA4.
GA4, my
is
lord.
my application under Order 7, Rule 10, your lordship.
No, I'm looking at the plaint.
Page
Plaint,
8.
Yes.
My lord, we'll obtain instructions in that regard, my lord, because our prayer is for 13 lakhs, 30,000, my lord. We'll take.
Must you accept without prejudice? 10 lakh?
Yes, yes, my lord. My lord, we'll come back.
No question of coming back. Ashun.
My lord, what has happened? We have prepared the machines, even though we have some counterclaim because the machine are made.
Ask your client to pay 10 lakh as you have committed for the time being without prejudice to the rights and contention of the parties.
My lord, that's very fair, my lord. What I'm submitting, the suit can be resolved, my lord, if they are willing to accept as a one-time full and final payment, my lord.
My
We
lord.
just found this can
All
be
right,
fully
I'm recording an order.
Correct, my lord.
Kiki item bolla?
4 and 30, my lord.
4 and 30.
30, my lord, I'll just indicate, my lord. This is for
no question of any further indication if the suit is settled.
My lord, there's an interim order that is subsisting in my favor.
Let it subsist till the it's expiring.
My lord, it is expiring today, my lord.
Today?
Today.
I will extend.
Yes.
Don't worry. কি বললাম 4 and 30 একসঙ্গে order করো. Now under which heading, Mr. Ghosh or Mr. Dev, Mr. Sudip Dev, senior counsel, come in the front. Who is there? Yes, Mr. Dutt. Yes. Be the amicus. Under which heading I shall direct it to appear? New chamber, motion adjourned. Whatever, for what doesn't matter today. It really doesn't matter the order of the day. New chamber and adjourn motion.
One application is new chamber.
Better I don't direct it to appear. Asha.
Liberty to mention.
Take a seat. কি বললো দুটো একসঙ্গে করে দাও যা হবে হবে ভেবে লাভ নেই লিটিগেন্টটা যাতে সাফার না করে তাহলেই হলো plaint filed for price of goods sold and delivered.
My lord, advance payment made.
Advance payment.
Okay. The suit filed by the plaintiff claiming a sum of rupees 13,030,000 13,30,30,000 এটা বোল্ড হবে along with interest on account of return of money lent and advanced. আচ্ছা এটা তুমি করবে কিন্তু ওই এই জিএটা লিস্টে নেই চেম্বার না চেম্বার আছে তো এই দুটোই আছে তো তাহলে দুটোর তোর আন্ডারই করে দাও পোস্টার মিস্টার
Amulya Dhingra.
সরি
Amulya Dhingra.
আমি বুঝতে পারছি না বলে দেবো লিখে দাও
Amulya.
Learned counsel appearing through virtual mode for the defendant, comma, on instruction from his client, submits that the defendant is ready and willing to pay rupees 10 lakh once for all.
Yes, my lord.
So that upon payment of such sum, the dispute can be resolved poster. This submission is without prejudice to the rights and contention of the defendant.
Very well, my lord.
Paragraph. So you can come up with the terms of settlement.
I can propose and discuss with my counsel on the other side.
The parties, if agree on these terms or whatever terms they will agree, they shall prepare a terms of settlement in accordance with law and
Yes,
file
my lord.
them before this court on the next day.
Very well, my lord.
Paragraph. Mr.
Chitresh Saraogi. My lord, I'll mention the name. Chitresh Saraogi.
Learned, Mr. Such and such learned advocate appearing for the plaintiff informs this court that the interim order,
Lord, interim order is expiring today. My lord.
when passed, when
My lord,
extended,
it was passed on the 9th of August 2024.
the interim order passed on
9th
August
of
9,
August 2024, my lord.
2024.
My lord, it was
Last extended on
22nd September.
আরে ভাই একটু অর্ডারের
18th
কাগজগুলো দাও
September.
বাবা
18th September. Lord, I'll hand up.
দেখি একটু এগুলো দিতে হবে না না আমি কি করে করব ওইটা দেখি কি September 18, 2025 expires today. Full stop. Paragraph. Accordingly, the interim order stands extended till February 16, 2025 or until further order, whichever is earlier.
2026, my lord.
The matter shall appear under the heading New Chamber Application or for settlement.
My lord, for
Under the heading for settlement. Under the heading for settlement. On December 18, 2025.
my lord, settlement talks, my lord, we'll have with them, my lord. If we are agreeable, my lord, we'll report.
Chalo, next.
Oblige, my lord.
Timber application for final dispose of item number 5.
আমাদের 5 5টা 5 হচ্ছে আমার স্ট্রাইকিং আউট টিপি 5টা হলো আমাদের রিফ্রেশ না কেন
One, he is the petitioner, one, I am the petitioner. Point is very simple. Whether the whether the whether the court will grant me leave to disclose documents. He is opposing my right to disclose documents.
Your application for disclosure of documents on the basis of the written statement.
And documents which also he will be relying upon.
Which
he will be also relying upon.
That's different, but yes, what is and what is your application?
Striking out of defense because there were directions for discovery inspection which they did not comply, as a consequence of which, my lord, it has to go. It's a commercial suit.
A commercial suit, but
And
is
so,
there
my lord, the documents
any extension is possible? What do you
of,
think?
in law, my lord, it's
Extension is
not possible.
Extension I
Show me.
already have.
Oh,
Extension I
extended period is running.
Extension is already have. I have filed an application pursuant to that. I have disclosed documents, gave him inspection. Now he says that I am not going to take inspection because the documents which you are relying upon.
Not give him inspection.
Anyway, I have offered inspection. The letter is there. He says I am not going to take inspection because the documents which you are relying upon is not part of your pleadings.
How will I take it?
Part of your pleadings. So the original will not be given inspection.
I have offered inspection. He doesn't want it because he feels that once he takes inspection,
Written
then
statement of the
consequence. I don't know what consequences will follow. If he doesn't take inspection, he is at his.
That's his call. That is his call.
But may I, my lord, just clarify in this
Who
matter?
you are who?
I am for
His
the
rights have been closed.
Not really.
Who are you?
I am defendant number 2. Mr. Dutt is appearing for
Dekhi,
defendant number 1. Now, my lord, same plea was taken against me. I have already filed a written statement. Now, my lord, by the last order, this honorable court has clarified that my right to rely on certain documents stands good because documents are common documents. So, therefore, with regard to this, my lord, I have nothing to say because court has clarified since you are relying on a certain documents which are common documents, plaintiff has also relied upon, you would be able to rely upon those documents at the time of trial.
That I think is
Dr. Saheber application and নম্বরটা কত?
So, my lord, to that extent, I am through.
DS6, no.
And that, my lord, this court has clarified by an order dated 11th August 2025. I thought I should point out.
Yes. What is your case?
My case is, my lord, I have pleaded in the written statement.
No. What is your prayer now?
I have no prayer. My stand has been clarified. Kindly have a look at this 11th August.
Absolutely incorrect.
What is correct or incorrect, that will be reflected in the order. Mr. Ghosh, relax.
No, I don't need that advice.
I know you don't need any advice.
Wait. Let me read.
It's absolutely unclear.
Let me read. Counsel for the defendant number 1, which means Mr. Dutt.
Mr. Dutt.
Okay.
Kindly come to internal page 2 once.
Wait.
এর আগের অর্ডারটা হ্যাঁ অগস্টে আর ও রাইটটা যেটা ক্লোজ করেছে সেই অর্ডারটা দাও নাম্বার 2 এর রাইটটা ক্লোজ করলো না
এই এটা একটু জল দিয়ে দাও।
But by an order dated 8 May, certain restrictions were imposed. I'm sorry.
If I rely on, he'll get a chance. If I rely on any topic,
এটা তো
he can
রেগে
rely
যাচ্ছে
on
কেন
that.
মামলা করতে করতে?
ভাই, আপনি না মিথ্যে কথা বললে অসুবিধা হয়।
তাই নাকি? এরকম তো কেউ বলে না যে মিথ্যে কথা বলি আমি ভাই।
In any event, Mr. Dev, your client has disclosed.
No.
Oh, plaintiff has disclosed.
Yes.
Disclosed. By an
Lord,
order
you
dated
kindly see me 8.
Plaintiff has disclosed.
Plaintiff disclosed. By
In its plaint,
yes,
right?
I could not do it in time. So by an order dated 8th May 2025, Lordship sees, if Lordship have looked at this order. Court said, no, you can't rely upon certain documents.
Yes.
Whatever you have pleaded in the written statement, you can go ahead, but no disclosure or no reliance on any documents. Now, by this order, when the matter was came up, I pointed out documents which I wanted to rely upon.
They have already disclosed.
Common documents. So nothing prevents me. So that has been
It's all on
clarified.
record.
That's right. That is
If
exactly
you want
what I
to,
wanted.
what clarification you require?
I don't require any clarification. When this point today, Mr. Dutt and Mr. Ghosh will be fighting, I thought
You're not in it.
I am not to that. But
So just be outside the scope of the application.
that's right. So, my stand has been clarified and I was permitted. This is exactly what I wanted to show, what has been recorded in the order. That's all. So, what incorrect submission I have made, I do not know. Maybe he will be able to tell.
Yes, I will now. Lord will kindly see, my lord, the order of May 8, 2025.
Give me.
This is pertaining to Mr. Dev's client. State of West Bengal.
No, Mr. Ghosh.
My lord, his
State
right,
of West Bengal being defendant number 2. I will not touch him.
yes,
Matter
and his
ends.
right has been closed.
Sir, whatever right closed, not closed, what order is there? So I am not touching defendant number 2. Now fight with Mr. Dutt and
Yes,
Mr.
Mr.
Dutt
Dutt's
will fight with Mr. Ghosh. That's all.
That is all. Mr. Dutt's application, my lord, press.
আচ্ছা 1 মিনিট একটা প্যারাগ্রাফ লেখো।
So Mr. Dev's contention that he's been allowed.
You listen to me, what order I pass? Mr. Shuman Datta, learned senior advocate. Now, first হচ্ছে Mr. Shoumamu Ghosh, learned advocate, appears for the plaintiff. Mr. Shuman Datta, learned senior advocate, appears for defendant number 1. Paragraph, এগুলো সব paragraph. Mr. Sudip Dev, learned advocate, learned senior advocate, sorry, appears for defendant number 2. What is your application, sir? GA?
6.
GS IA GA Com. IA Com, IA কি লিখে কিভাবে? IA GA Com 6 of 2025 is an application filed by the first defendant praying for.
I have prayed for leave, my lord, but I'll.
1 second, sir. 1 second.
Kindly take, my lord, the master summons.
Praying for leave to disclose documents mentioned in its affidavit of documents affirmed on April 7, 2025. Poster. Next, GA. Mr. Ghosh, your GA?
GA 5.
IAGA Com 5 of 2024 is an application taken out by the plaintiff praying for striking of defense of the defendant number 1 and 2 and the respective written statements be taken off the file. Post. Paragraph. Paragraph. Mr. Sudip Dev, learned counsel, senior counsel appearing for defendant number 1, has placed 2 orders dated May 8, 2025 and August 11, 2025, passed by the coordinate bench. Under these 2 orders, whatever right has been granted and conferred upon the defendant number 2, that remains. and this court finds no reason to interfere with it any further. Full stop. Accordingly, whatever right has accrued in favor of defendant number 2 under the said 2 orders, those remain, those remain. Shesh. Paragraph. Considering the nature of the 2 pending application, paragraph, as referred to above, this court is of the view that if IAGA Com 6 of 2025, Mr. Dutt, if IAGA Com 6 of 2025 is taken up for consideration first, depending upon its fate, the other application shall also be followed, shall also follow the result. Paragraph. Hence, IAGA Coms 6 of 2024 is now considered, is now being considered, is being considered. ঠিক আছে. Yes, Mr. Dutt, take me to your application. এই অর্ডার দুটো রেখে দাও, ওই অর্ডারে রেখে দাও, ফাইল তোমার কাছে রাখো. Yes.
Suit is
দেখুন, in the instant application, plaintiff has also filed its affidavit in opposition. You have filed your reply? Huh?
Yes,
Hey, reply কোথায়?
And a supplementary affidavit.
Where is that?
That we have filed.
এটা কি?
Well,
Volume 2.
I'll tell you why it is so voluminous.
To the supplementary. এই তো supplementary. এই তো supplementary. I find one volume 2. Check it out, check it out. Ask your advocate on record to check it out.
Yes, this is what.
Volume 2 of your application.
I'll tell you, Lordship, why your Lordship finds this to be like this. Lord, when I filed this application, my learned friend took an objection that the documents which are mentioned in the affidavit of assets, affidavit of documents, Lord, is a list. And those documents are not relevant for the purpose of. So the court wanted to know that what documents I am relying upon and why is it relevant. Because the court wanted to.
And first tell me, what is the suit all about?
Milord, Rasandik Engineering Industries India Limited, Milord, is, Milord, a company who is filed the suit against the dependent.
Mr. That take out the microphone. The acoustic is a bit problematic.
So, Milord, your Lordship, it will come back to your Lordship, Milord. That Shingur project, Milord, was initially supposed to happen in West Bengal. The Tata Shingur project. Now, when this project was, the idea was hatched, Milord, the plan was that Tata would create a factory.
No, 1 second. Mr. Sinha, Mr. Puritu Sinha. That arbitration I am hearing.
Getting us? The connected arbitration.
That I don't know.
That is the Tata Section 34.
Ah.
West Bengal Industrial Development Corporation, but this is a separate plaintiff, separate vendor of Tata.
This is the auto component supplier where there's no activity.
I'll tell your lordship. Thereafter, your lordship can take a call as to whether your lordship would.
No, I don't know because.
Let me just tell your lordship. So, my lord, what had happened is, my lord,
because in that matter, hearing has progressed to a greatest extent. So,
but let me tell your lordship. Thereafter, if your lordship feels that no, there is an embarrassment, my lord, obviously we won't stand in the way. So, my lord, so far as this project was concerned, this project envisaged that there would be an industry of Tata Motors, and there would be ancillary industries around which would, my lord, cater to the main. So, my lord, at the instance of Tata Industries, my lord, when this allotment was given, it was Tata who chose who would be the ancillary industries, ancillary vendors. My learned friend client is one of them, who is the plaintiff.
Is one of the chosen entity.
And pursuant to that, my lord, we have allotted the land to him. That is not in dispute. Now, my lord, the matter your lordship knows got litigated. It went up to the Supreme Court, and ultimately the acquisition.
Hey, Asteo.
And ultimately the acquisition was set aside. Now, once the acquisition was set aside, my lord, whatever allotment money we took, we refunded, but that's on merits. We are not concerned with it right now. Now, after we have settled, my lord, and the disputes, the Tata went into arbitration, and this, my lord.
That's what I'm.
Yes, let me tell you, lordship, my lord, maybe your lordship may feel embarrassed. And so far as this plaintiff is concerned, he's filed a suit against the plaintiff number, defendant number 1 and 2, seeking recovery of damages on the ground that I have invested such entire amount and they have gotten. Now, my lord, when this suit was filed, my learned friend initially filed a suit. According to us, the suit is barred by limitation, but he filed the suit on a very urgent basis. And therefore, according to him, he could not disclose all his documents along with the plaint, although it's a commercial suit. 2 years during the pendency of the suit, after 2 years, my learned friend filed an application saying, after I have already disclosed my defense, saying that no, since during that time I did not have access to
this. Let me not take up this matter. Let me not take up.
But my lord, so far as this is concerned, may I indicate one thing? Your lordship need not go into this because kindly come to my application. My application is for leave to disclose.
No, sir.
No, sir. Just 1 minute. If your lordship thereafter feels that there is
No, sir. I tell you.
There is nothing to be adjudicated.
That matter has been progressed substantially. Substantially.
Please. Entirely your lordship's call.
Please, sir. Please, sir. Ashu.
The previous order,
Huh?
the order which your lordship passed, then let it. I want it to.
But
stay.
that is only recording.
Yes,
what
that
has
is
already happened.
exactly. So there's no difficulty. The order that your lordship passed right now, my lord, just before taking up this matter, my lord,
Mr. Debs,
we want that order to stay.
No. I have expressed my opinion that I'm not going to so total the suit and the connected applications stand released from my list on my personal ground.
It's not a personal ground, Millard. This is something else.
What do I say then?
It's not a personal ground. Your lordship is embarrassed because your lordship is hearing.
Achha, very well. Released from my list, since I'm hearing an arbitration proceeding, though the plaintiff is not a party there, but the ultimate project is the same.
And the documents which I'll rely upon is the documents in that arbitration.
Ultimate project is the same, but arising out of the self-same project. কি বললাম পড়ো? But arising out of and or connected with the self-same project. Paragraph. Paragraph, the matter stands released from my list. Paragraph, the records are directed to be sent forthwith to the Secretariat to the Honorable the Chief Justice for taking steps for assignment.
Can be one of the grounds for again sending it back to your lordship. The better position to
Better to assess the fact.
That matter is hotly contested.
Heavily contested.
Suit and the application.
Or suit and all connected applications. That matter is hotly contested. Mr. Dotto knows. He appears there.
Great.
I'm so sorry. So sorry. So sorry. এইটা কিন্তু এই দুটো মামলাতেই অর্ডার হলো। Thank you.
Pilot item number 7, I am for the plaintiff but respondent. The application which is appearing before your lordship.
For rejection of plaint?
No, it is for stay of suit. It is for stay of suit, and I have used an affidavit in opposition to which no reply has been filed. May I be permitted to bring this on record? The affidavit in opposition.
Wait.
Yeah.
I will.
Milord, this is my application, Milord.
Wait.
Milord, I'm extremely sorry. I'm out of time, Milord.
ঠিক আছে, wait. This is an application filed by
Defendant number 4, Milord.
the defendant number 4. This is an application filed by the defendant number 4. Paying for stay of the commercial suit and the consequential interim order. Paragraph. MS Shuchishmita Chatterjee.
Ghosh Chatterjee.
Ghosh Chatterjee. Shuchishmita Ghosh Chatterjee. Any bracket? Ghosh Chatterjee, Learned Counsel, appears for the plaintiff. Mr.
Rohit Banerjee.
Rohit Banerjee, Learned Counsel, appears for the defendant number 4. Any other defendants are appearing by any chance? Mr. Come on, tell me your name. Oritro Deb, Learned Counsel, appears for defendant number 1. MS, সব কিন্তু প্যারাগ্রাফ, ওই একটা প্যারাগ্রাফে নয়। MS Ajaya Chaudhary, Learned Counsel, appears for defendant number 2.
Number 7.
Mr.
Debanjan
Mukherjee, Learned Counsel, appears for defendant number 7. Anybody else? Paragraph. On the prayer of the Learned Counsel for the plaintiff, who is respondent in this application, time to file affidavit in opposition stands extended till today. Full stop. The affidavit in opposition filed in court today is taken on record. Full stop. Copy has been served upon the plaintiff. Will you reply?
That copy has been served upon the defendant number 4.
Within time.
Copy has been served upon the defendant number 4 applicant.
Milord, I am out of time. I'm only seeking for 10 days extension, Milord.
Paragraph. On the prayer of the Learned Counsel appearing for the defendant applicant, time to file affidavit in reply stands extended till December 23, 2025. The matter shall appear under the heading Chamber Application for final disposal in the monthly list of February 2025. 6.
Only thing, if your lordship kindly queries the
2026.
order dated 4th of September, there was a direction given to serve the copy to all the parties. We have not received.
Why it is material?
It is not
Section
required.
10 by one particular defendant. If the suit is stayed, it will be stayed as against him, not against all the defendant. So where is the
Since there is a direction, my lord, I have placed before your lordship.
My lord, there is also, I don't know whether I should point it out right now or not. There is also another application which is filed by the defendant number 4 against the plaintiff, seeking rejection of the plaint, but that has not been coming up in the list. So that
Master summons taken out on 16th September.
15th of September 2025, the master summons
Served,
was
my lord.
taken out and was served also, but it has not been coming up.
On the submissions made by the learned respective counsel for the plaintiff and the defendant number 4 applicant, there is an application pending.
That should be GA 10 of 2025.
There is an application pending being IAGA Com 10 of 2025, where dependent number 4 prays for rejection of plaint. The same by consent of the parties shall also appear along with this application in the monthly list of February 2025 under the same head 2026 under the same heading.
Will your lordship give directions in that, but because it's not appearing today in the list, that direction also perhaps have to wait. Otherwise, affidavit direction, because the matter is made returnable in the monthly
He has
list of
to
February.
choose one.
Yes, that is why I'm saying.
That the doctrine of election
Yes,
will come.
they have to elect either one.
Doctrine of election will come. The plaintiff shall file. Now, accordingly, shall appear along with the instant application under the same heading. ঠিক আছে আর কিছু ফেব্রুয়ারি আর সেকেন্ড টাইম বলার দরকার নেই প্যারাগ্রাফ by consent of the parties the said application for rejection of plaint is being treated as on days list and directions for filing affidavits are met. Paragraph. Plaintiff shall file its affidavit in opposition on or before December 23, 2025. Affidavit in reply, if any, thereto shall be filed by January 20, 2026. Bas. ও তো আসবে একসঙ্গে।
Grateful to.
Deeply obliged.
Thank you. ওই যেহেতু আপলোড হওয়ার দরকার নেই তো এইটা আপলোড করে দাও ওরাই নিয়ে চলে আসবে অর্ডারটা
Number 8. I'm appearing for the defendant number 1. Appearing for the defendant number 3.
Appearing for the plaintiff, your lordships.
8 and 9 একসঙ্গে আছে
Yes, your lordship. I am appearing on behalf of the plaintiff, Mr. Deepak
yes
Jain is
yes
speaking.
yes
Let me address your lordship. There are two applications. One for filing a written rejoinder to the counterclaim filed by the
sorry
defendant number.
take the microphone.
Lordship, there are two applications. One for seeking leave to file a written statement to the counterclaim filed by the defendant number 3, and there is one more application for acceptance of the written statement of the defendant number 2. I am aware of your lordship's view in your lordship's latest judgment, but there also there was a direction for opposition. I am out of time, your lordship. I am seeking for extension by only 2 weeks. Your lordship, I'll file that opposition, and thereafter your lordship can pass the order. And with regards to the other application, there also I have liberty was given to me
তাহলে
to file
দুটো
my
মামলা
opposition.
একসঙ্গে করে দাও করে একটাই অর্ডার করো
2 weeks, your lordship. I'll come back.
in re GA where you are filing praying for opposition in re GA
Both 7 and 8.
oh both your
Both 7 and 8. The direction was passed together. I am out of time.
দেখো Who is for the plaintiff?
I am for the plaintiff.
We are appearing.
You are for the plaintiff.
Yes, Minister.
Oh, extension
No,
paid by you.
GA7 is mine. Milord, where I likely to file, Milord, my written statement, additional written statement against the written statement filed by defendant number 3. Milord, they have raised allegation against
So
me
the additional written statement
or a rejoinder, Milord, whichever way.
rejoinder is not permitted.
Additional,
Listen by the plaintiff.
no, by the defendant number 1.
Defendant number 3, Milord, I am
Milord, he is appearing for
See, let us be clear on the perception first. That I know. If a counterclaim is submitted by the defendant, additional written statement is to be filed by the plaintiff. If you are not for the plaintiff, then how will you file your additional? You are a co-defendant.
I am a co-defendant.
Sorry,
Number
no.
1. Milord, I shall satisfy, Milord. I have a under law.
You may satisfy at the time of hearing.
Yes. Milord,
The law never permits you to do this. You have to dislodge the claim or disprove the claim of the plaintiff on your independent stand. Sorry, no.
Milord, I shall satisfy. Kindly keeps it
I
for
am
hearing.
rejecting your prayer.
Milord, I shall
Test it. Come on. There must be some limit somewhere.
It was argued before the earlier bench also. Lordship, I am appearing for the plaintiff.
Mr. Jain is leading me with the Lordship's leave. Let Mr. Jain address your Lordship.
Mr. Jain
is leading me in the matter.
No, I am. First, let me hear that whether co-defendant can file an additional written statement.
Definitely. Yes, Your Lordship.
Ashud. Which application?
GA7.
GA7 of 2025 is an application filed by
the defendant number 1.
Defendant number 1. Internally are praying for leave to file rejoinder and written statement. Rejoinder and written statement.
Additional statement is already there.
अच्छा ठीक है वो सब ना भाई कोट करो या दिन कल ना बोलना internally are praying for quote prayer C2C quote 1 quote 1 from master summons GA7 আচ্ছা এটার মাথার উপর লেখো ইনরে GA7 of 2025 ওরে তার আন্ডারে এই অর্ডারটা হবে ওটা লিস্টে আছে তো এই সব মামলা লিস্টে আছে তো GA7 paragraph shown learned counsel appearing for the defendant number 1 applicant Mr.
Kushal
Chatterjee submits that he is a co-defendant in the suit along with other defendants. Who has filed a counterclaim?
I have filed.
Defendant
number 3.
Defendant number 3 has already used a written statement in which a counterclaim is there. Defendant number 1 prays for leave to file a rejoinder and written statement in response to such counterclaim filed by defendant number 3. To give all your names, who is appearing for whom? Paragraph. To this court, it is an alien concept in law. The law established by procedure.
Milord is passing order in this application because GA7.
Yes.
Milord, kindly place me there. Allow me to place the law, Milord.
Yes. বললাম ওই অবধি রাখো, মিস্টার such and such submits.
Kindly takes up.
Submit. Stop it, but dependent number. Yes, sir. Show me the law.
Kindly takes up the written statement of defendant number 3 first. Firstly, the fact.
Ache, written statement. Give me your copy.
Defendant number 3 written statement copy. আরেকটা কপি আছে? Kindly excuse me, this is mark. একটা কপি দেন ডিফেন্ড। In the written statement of defendant number 3, I tell
Take the microphone properly. Yes.
In the written statement of the defendant number 3, I tell your lordship the facts first. I have a defense, against the plaintiff's case that I being a company situated in Kerala, having his head office in Kerala, and defendant number 2 being an employee at that point of time, has exceeded his authority, in entering into a contract independently, without any authority given by defendant number 1 with the plaintiffs, and defendant number 3 has also acted independently.
I'm not on facts.
No.
First, you show me the established procedure.
Yes,
that you can file an
I shall.
Rejoinder or an additional written statement being a co-defendant to another defendant.
Yes.
You show me that.
Yes, yes.
I'm not interested on
law will come, on the basis of the fact.
No, sir.
Order
here it is not that case.
Kindly.
It is the procedural law. Show me the procedure.
Kindly takes up order 8 rule 9.
Order 8
rule 9. What has got it, my lord?
Order 8 rule 9.
Yes. What has found, order 8 rule 9? Subsequent pleadings.
Yes. Yes, sir.
No pleading subsequent to the written statement of a defendant, other than by way of a defense to set up or counterclaim, shall be presented except by the leave of the court, and upon such terms as the court thinks fit. But the court may at any time require a written statement or an additional written statement may from any of the parties, and fix a time of not more than 30 days for presenting the same. So, there are two situations, or rather 3 situations contemplated. I have filed my written statement. This is a subsequent pleading which is coming on record. To dealing with the stand taken by the defendant number 3. Now my lord has to, I have to apprise my lord that why this is necessary. Then only my lord will allow, why this subsequent pleading by way of an additional written statement to come on record.
No, but it is an independent cause of action. Even if.
No, this is a composite suit. This is stop just, the reason of incorporating this provision is to stop a multiplicity of proceeding. Everything should come under one suit. I should not go around, several suits and, deal with each and independent claim made by each and every parties. So, I have to deal.
It is a plaintiff's claim against you, inter alia against you.
Yes.
Along with 10 other defendants.
Yes.
Right? So, to what extent, if you plaintiff can prove your liability?
I give you an example. Now, suppose, I have 10 array of defendants. 2 or 3 defendants, files a written statement. Subsequently, the other defendants come in and supports the case of the plaintiff, rather supporting the case of the defendant. What happens then? They make out independent case, these defendants, blaming the other defendants. That this was the scenario, I am blaming the defendant number 1, thereby supporting the case. Now, my lord, in that juncture, my lord, when a new stand has been taken by the defendant, other defendants, the primary contesting defendant has a right to deal with those statements. That is why this subsequent pleading comes in. If I do not traverse,
But in that case, there is no scope for proving or disproving a case amongst the co-defendants. That cannot be the situation.
No, my lord, I'm dealing. Yes.
Plaintiff institutes a suit for whatever cause of action against 10 defendants. Now, let's say part of such cause of action against defendant number 3.
Yes.
So, plaintiff has to prove it against defendant number 3. If it is not proved and the case of the plaintiff is dislodged by the defendant number 3, then there will be no decree against defendant number 3.
Absolutely.
Straightway. Now, defendant number 3 has every liberty to disclose whatever documents it will disclose,
yes,
including if a document which is not an inter-party document. It may, because the process for subpoena is there for that.
Yes.
Correct? So you have every liberty to disclose whatever documents you want to disclose in your own way, in your own wisdom. Now, you have to show that, look here, these are the documents. I have no responsibility. It is the responsibility of the 10th defendant. If you can prove that by dislodging the claim of the plaintiff against you, plaintiff will not get a decree against you, and you will succeed in the suit by dismissing the claim of the plaintiff against you.
Now, my lord, I have understood what is falling from my lord. Now, my lord, what I try to apprise my lord, this is pleading. My lord, if I, my lord, suppose whatever my lord is saying, my lord, is a procedure, my lord, at the trial which I will adopt. Now, my lord, suppose, my lord, I have to deal. My lord, suppose the basic fundamental of law is, my lord, something which is not in pleading. I cannot go and lead evidence or prove.
You cannot go travel beyond the pleading.
Travel beyond the pleadings. Now, my lord, suppose the other defendants, my lord, takes a stand and makes the defendant number 1 liable. Suppose today, my lord, GA 8.
It cannot be a stand. It cannot be within the scope of the suit,
yes,
because then it becomes an independent suit between defendant to defendant.
No, my lord, I tell you, my lord, suppose, my lord, defendant number 8, my lord, the defendant number 4 who has filed GA 8. My lord, GA 8, the other GA. My lord, suppose, my lord, defendant number 2, my lord, we have not seen the written statement. My lord, he comes up because entire dispute.
So you are suggesting that all these 10 defendants must exchange written statement amongst themselves.
No, my lord, I have a right to, my lord, have a copy of the defense taken from record.
Sorry,
it has been served upon us.
Show me the law.
Yes, my lord, that's why I'm placing. My lord, this subsequent pleading, my lord, I'm stressing on the word pleading. Why pleading? It's not, my lord, pleading will include plain written statement, everything, rejoinder, replication, whatever.
Whatever.
Now, my lord, this provision, my lord, is one way of, my lord, dealing with a counterclaim and set off. Now, my lord, in the
counterclaim and set up against whom?
Lord, they have pleaded against plaintiff. My lord, they have not played a counterclaim against us. So, my lord, I am not on the first part.
He cannot.
I'm not against the first part.
He cannot plead.
Now, my lord, the second part is shall be presented except by the leave of the court and upon such terms as the court thinks fit. Then, my lord, other than this defense against the counterclaim of set off, my lord, with the leave of the court, I can file an subsequent pleading.
No.
Because the language is other than set off and counterclaim.
Absolutely, I agree, but it will be filed by whatever claim is there by one defendant. Let's say defendant number 8.
Yes.
It is against the plaintiff. A plaintiff institutes a suit against 10 numbers of defendants. Permitted?
Yes.
8th defendant comes up with a defense. Look here, I have this claim against the plaintiff. Right? So it will be treated as a counterclaim. Correct? Plaintiff will have an immediate right to use an additional written statement. Otherwise, it is basic and elementary principle of natural justice.
Right? Yes, I'm understanding.
But
what is
it does
troubling.
not
It was also
permit-
troubling to my conscience also, because I'm using a Miller defense additional written statement against the stand of the defendant number 3.
Show me that
Miller,
law.
to satisfy myself.
Show me that law to your satisfaction of
Now-
yourself
now,
immaterial.
Milord, this provision is the only enabling provision where Milord subsequent pleading or an additional defense may be raised. Milord, there is no other provision. Now, Milord, to avail this provision, Milord, I need to show before my Lord that today defendant number 3, Milord, my entire case is, Milord, both of defendant
Sir,
number.
I accept your submission.
Bear me for a moment.
1 second. Now, let me clear my mind. I accept your submission that defendant number 3 has made a claim against you.
No. Milord, he has taken a stand where he says that
all responsibility was
belongs
yours.
to me. And Milord, he has denied the stand which I have pleaded in my written statement. Now, Milord, in this situation, when he says that defendant number 1 is solely responsible, I am nowhere in the scene, Milord, with a specifically categorical stand taken that I have done everything, Milord, then it's my duty cast upon me, Milord, in the law of pleading, Milord, to traverse those stands. Because this is something, Milord, which is coming up for the first time against me.
So, suit within the suit.
The
suit within the suit.
Not a suit within the suit. It's a Milord.
Your
pleadings
mere,
within the pleading.
no, your mere traversing will not do. Then again a witness action where that 8th defendant will be the plaintiff and 10th defendant will be the defendant.
Now, Milord, along with this stand, Milord, he takes a counterclaim, maintaining the same stand. Now, Milord, in counterclaim, he is transposed to the place of plaintiff. So, Milord, he has an independent stand now as a plaintiff. So, Milord,
against,
Milord, though the prayer
against
the plaintiff against the plaintiff. Now, plaintiff becomes
is not a
defendant.
plaintiff against the
Plaintiff
plaintiff.
now becomes a defendant. In
Yes, it
counterclaim.
will be treated as a plaint.
Yes. So, Milord, in this case, Milord, he has an independent plaint now.
No, against even if it's the plaintiff.
Yes, Milord, this counterclaim is a separate suit altogether.
Absolutely, the plaintiff.
So, Milord, in the plaint, Milord, I am also a party. Milord, he has not struck me out as a party. No, it's not their stand also. So, Milord, as a defendant in that independent suit also, Milord, I have a right to file my defense.
To whom?
Against the Milord counterclaim
of the
defendant number 3.
So, suit within the suit.
Milord, that's the law. Milord, I
Show
cannot.
me the law. I want to see the law.
Milord, for the defense in the counterclaim, I need not ask for leave also.
Show me.
Milord,
No,
that is the first part.
To institute the law counterclaim.
No, to have a defense against the counterclaim.
By a co-defendant.
Yes.
Show me the law.
Milord, that's a order 8.
Come on, let's read.
First, no pleading subsequent to the written statement of a defendant other than by way of a defense to set up a counterclaim. So, Milord, this is other than. So, he has a counterclaim. So, I have a defense. Milord, though the prayer may not be directly affecting me, but the stand in these pleadings do affect me.
So
I
there
have
will
a defense.
there will be another trial in between the two defendants.
Suppose, Milord, today
you are suggesting that.
I'm not suggesting, Milord. The law is today, Milord, this suit. Milord, suppose, Milord, my suit fails. His suit fails. This
Maintenance.
No, the counterclaim survives.
Counterclaim survives so long plaintiff is concerned.
No.
Not against you.
Against, because I am the party there. I have a
Then-
right to participate there.
Yes, but it is not a counterclaim against you. Then then that defendant has to institute another suit against you and you only, where you will be the defendant and you will file your written statement.
Milord, I give another, Milord, a proposition. Milord, today, Milord, in an abundant caution, a defendant is added in a suit. Milord, no relief, nothing is there against him. Now, Milord, this defendant against whom no relief, nothing is there, if he comes to court and files a written statement, is it a law? May I put this question to myself? Court will say you need not require to file a written statement.
So long he is a party?
Exactly. But so long I am a party in the counterclaim,
No, you are
I have
not
a right
party
to
the
come and file a
counterclaim.
defense.
Counterclaim is always against the plaintiff. not against
Subject to correction,
intersect.
my lord, the law is.
Show me the law.
My lord, I cannot find the law which is not there. My lord, the law is otherwise. How can I say, my lord, kindly takes up
So get the law settled by higher forum.
Order 8 Rule 10. Where any party from whom a written statement is required under order.
Let us read slowly.
Yes, yes. My lord,
Procedure when party
fails
fails to present.
written
Parties fails to present written statement
Yes.
called for by court.
Yes.
Undefended suit. Come on, read. Where any party,
from
read
whom
on.
a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court as the case may be, the court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit. On the pronouncement of such such judgment, a decree shall be drawn up. Then Milord kindly takes up. Milord, this is why I am showing this. Milord, today, Milord, in the counterclaim, suppose Milord, I do not file a defense. So, my lord would record in the counterclaim there is no written statement filed by the defendant number 1.
No, no, no.
Then again.
But the court will record that the defendant has failed to prove his counterclaim against the plaintiff.
My lord kindly takes up, my lord, Order 8 Rule 6G. Now. The rules relating to a written statement by a defendant shall apply to written statement filed in answer to counterclaim.
Rules relating to written statement to apply. The rules relating to a written statement by a defendant shall apply to a written statement filed in answer to counterclaim.
So, my lord, I have a right. If the rules of written statement
the rules relating to a written statement, by a defendant shall apply to a written statement. To a written statement filed in answer to counterclaim. So, who shall answer to counterclaim?
No, my lord.
Who shall answer the counterclaim?
All the defendants in the suit?
No, the plaintiff.
Subject to correction.
Counterclaim is always against the plaintiff. No, so then who has to answer?
But today,
show me that counterclaim is maintainable in between co-defendants and the trial within the trial is permitted. Show me.
Milord, kindly takes up Order 8 Rule 1 and then 6G, Milord, reads harmoniously, Milord, for my satisfaction.
Yes, yes.
The defendant, Milord, has got it. Milord.
Order 8 Rule 1. Yes.
The defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense, provided that where the defendant fails to file written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. My lord, this provision says, my lord, as many as those who are defendants in a suit will have a right to file their defense. My lord, this doesn't qualify this provision.
He has a right to file written statement within 30 days. Then upon satisfaction of court,
much later date can be given.
Within 120 and not on the 121st day.
This is applicable to commercial, but in normal regular suit that can also be extended. Now, my lord, to this.
No, other than commercial, extensions permitted.
That's exactly what I'm saying. Other than commercial, extension permitted. Now, my lord, this provision, my lord, says it will not qualify whether any stand is taken against a defendant or not. It says a defendant in a suit will come and file his defense. It is irrespective of the pleading, whether that pleading
defense to against whom?
Against the plaintiff.
Matter ends.
Absolutely. So, my lord, it will not, defendant will not say that since there is no pleading, I will not file a, that's his prerogative. He will file or not.
Show me the law that two things. Co-defendant can maintain a claim against a co-defendant and trial within trial is permitted.
Lord, to that first proposition, co-defendant can maintain. My lord, I shall, my lord, I have not brought that decision where transposition, when court.
Transposition is a different concept for partition. Transposition is a different concept for other few types of suits.
Yes, where a
Not for all.
co-defendant, my lord, takes him to the position of a plaintiff.
Absolutely, but this is not in a commercial transaction.
Now,
sir, let us not argue such a manner, unnecessary wasting the time.
Lord, then I straightly, my lord, because my lord is of the view, my lord, I have a no right to file a, my lord, subsequent pleading.
I am not saying so. I am saying a co-defendant in a suit cannot contest the claim of another co-defendant. You can do whatever against the plaintiff. If the plaintiff fails to prove its claim against you and you, the suit will fail against you. The suit may succeed against other 9 defendants, but it may fail against you. Similarly, you have to take a defense, right? You have to take a defense to dislodge the claim of the plaintiff against you. If you succeed, the suit may succeed against rest 9. Against you.
Just one proposition, I will straight away go to two judgments, my lord, I will rely upon. Before that, a proposition, my lord, to apprise, my lord, what I am trying to say. My lord, suppose, my lord, today I file a suit, my lord, for declaration of title. My lord, the defense comes in, my lord, he is not the owner, I am the owner, defendant number 1 says. My lord, there are other defendants. The defendant number 3 is all of a sudden comes and says, no, neither the plaintiff nor the defendant number 1. It's me who is the owner.
He has to prove his
now, my lord,
case.
when, my lord, I take a stand that no, defendant number 3 is also not the owner because
the answer is within your statement. If the other defendant says, I am the owner, neither the plaintiff nor the defendant, so he has to raise a claim,
yes,
right?
Yes.
And if he succeeds to his claim that he is the owner, will he get any declaration?
No, my lord, then, my lord, exactly, my lord. Then, my lord, relies upon, my lord, handing over this pretty old.
Give me a copy.
I shall hand over this pretty old, my lord. Copy.
You can. Today it is all printed from.
I tried to. It's
online.
not available in SCC.
Very good.
AI at 1949 Odisha 77.
49 Odisha.
36. This is actually ILR Cuttack.
For AIR
1949
Odisha
page 77. Millard in bracket kindly writes 36 because the SCC online doesn't have that format of 36 writing. That's why it's not. Proposition. Millard, I'm just giving that nutshell what happened here. Millard, a revision came up before the Honorable High Court. Millard, here, Millard, the question came up. Millard,
sir, first take me to the
facts. Millard, I'm reading.
First take me what has been held.
That the right of a defendant to file, Millard, order 8 rule and additional written statement or a subsequent pleading when arises. Millard, this was the proposition, Millard, where it was.
Take me to that paragraph.
Millard, Millard, I'm just giving the nutshell. Millard, what happens, Millard, plaintiff, Millard adds, Millard, at defendant number 2. Millard, this defendant number 2 takes a stand which is contrary to defendant number 1. Now, Millard, the court, while looking at it, says, since a defendant is added and, Millard, a subsequent, Millard, facts have come in, this defendant who has filed a, Millard, written statement has a right, Millard, to deal with that. This addition, because he is absolutely going contrary to the, Millard, defendant.
To me.
And may I just read it over and then hand over the paragraph. But paragraph number 7, just please. The lower court appears to have overlooked the implication of surplus 5.
So what was the proceeding before the lower court? The application?
Application. Yes,
and its fate?
The application which was filed for will not file additional written statement or a subsequent pleading.
By
the defendant. That was rejected. Now, Millard, 7. The lower court appears to have overlooked the implication of surplus 5 of Order 1, Rule 10, which says that on addition of a party, the proceeding as against any person added as a defendant shall be deemed to have begun only on the service of summons and surplus folded.
So, an added party.
Added party, defendant.
Added party.
Added party.
Who was not there.
Who was not originally.
He has to file a written statement to the claim of the plaintiff.
Not the added party is not filing. The party who was already on record as a defendant, he is filing.
Against whom?
against the Milord stand of the added party and the plaintiff, because now the plaintiff adds a party who is supporting the cause of plaintiff. Now, then the defendant who is Milord giving his Milord defense, Milord, he files an application, allow me to deal with those facts. Then Milord, the court says it should be permitted. That's the Milord facts, behind the facts, Milord.
Achha, read it.
Only on the service and surplus for lays down that the amended copies of summons and the plaint shall be served upon the new defendant if the court thinks fit on the original defendant. Order 8 Rule 9 enables the court to require a written statement from any of the parties at any time. After the plaint was amended, the court should have called upon the petitioner to file an additional written statement if he chooses to do so, particularly after the newly added defendant has filed his written statement. In fact, it was the duty of the court to have given an opportunity to the original defendant. After the plaint has been amended and new pleadings have been brought on record, the petitioner raised two contentions in his additional written statement, which is thought to be incorporated in the original statement. Firstly, that the plaint and the defendant number 2 constituted a firm, and the firm having not been registered, the suit is not maintainable under Section 69 of Partnership Act. And secondly, that the contract between the plaintiff and the defendant number 2 on the one hand, and the petitioner on the other hand was void, and as it is contravened the provisions of Orissa Food Grain Control Order. Whether these contentions have any substance in them or not, it will be for the trial court to investigate, and it is now premature to say that they are frivolous. The lower court unfortunately was under the impression that the petitioner wanted to add certain facts to his written statement, which would substantially alter the nature of the suit or the defense. I am unable to uphold this view. The point raised by the petitioners are purely questions of law, and if they arise out of certain facts, this is a fit case in which petitioner should have been allowed to amend his pleading. It is alleged by Mr. Mahapatra appearing.
Who was the petitioner?
The defendant, the original defendant. He was the petitioner. The original defendant was the petitioner. That will be appearing. Revision is direct. First
that is the difficulty. Only one copy you carry.
First, the revision is directed against the.
No, it is not possible, sir.
Refusing to allow.
It is not possible for me.
This very kindly calls for this book.
You could have brought it from the library.
In the library, 3 libraries could not get this book. Well, I brought it from Mr. Anirudh Chatterjee's old chamber, my lord. Even I do not have this copy. It's his book, my lord, I am relying on.
No, but very well, I will deal with it. Next.
But first 3 lines of the judgment delivery portion, my lord finds first 3 lines held. The revision is directed against. Paragraph 7 I was reading and the first 3 lines. This is one. And my lord, I would rely just to show, my lord, what is actually the reason of Order 8 Rule 9 being incorporated in this, my lord, Code of Civil Procedure. My lord, kindly takes up, my lord, 2024 9 Supreme Court cases 353. My lord, though this is in an election petition, but my lord, the reason and the concept behind it, my lord, comes into play. 2024 Volume 9 Supreme Court cases 353. But I would be relying upon paragraph 22 onwards.
See, the basic difference in election petition, it is initiated by way of a petition, not by way of a plaint. But the procedure for trial is followed of a suit.
Yes.
So this will have no application in a civil suit.
This with Order 8 Rule 9, the concept. Lord,
concept may be applied for application. That's why in opposition and reply, if it is an application, 100 supplementaries are filed.
Yes.
But this will have no effect on a trial of a properly constituted civil suit.
But apropos this principle, Milord, kindly read this Orissa, which deals with, Milord, the same concept. What is
election petition will have no effect.
Allow me to place 20.
Paragraph
22 onwards. A plain reading of Section 87 of the 1951 Act would indicate that, subject to the provisions of 1951 Act and any of the rules made thereunder, an election petition is to be tried, as nearly as may be in accordance with the procedure applicable under CPC to the trial of suit. Order 6, Rule 1, CPC defines pleading as a plaint and a written statement. The object and purpose of pleading is to
Louder. Take the microphone.
The object and purpose of pleading is to ensure that the litigants come to trial with all issues clearly defined. Its object is also to ensure that each side is fully alive to the questions that are likely to be raised or considered, so that they may have an opportunity of placing the relevant evidence appropriate to the issues before the court for its consideration. A case not specifically pleaded can be considered by the court only where the pleading in substance, though not in specific terms, contain the necessary averments to make out a particular case. And the issue framed also generally covered the question involved, and the parties proceed on the basis of such case was at issue and had laid evidence thereon.
So now how the issue will be framed if your contention is taken to be correct?
Two issues, since there is a counterclaim. First issue is on the basis of the pleadings, plaint and the written statements filed by the parties.
So second issue between two defendants. It will not.
No, second issue is between the one whose counterclaim is there and
between the two defendants.
And the defendants.
So between the two defendants.
Subject to correction, what my lord is saying, there are. It's not between two defendants. It's an issue in a suit.
No.
Suit.
So plaintiff has nothing to do with it.
Suit.
What will be the role of the plaintiff if it is allowed?
Exactly, What is the issue in the present case? That's why I was taking my lord to the facts of the case.
Whatever the issue. So it will be an issue in between two defendants, not with the plaintiff.
It's its prerogative whether he will use defense or not. But why my prerogative is being taken?
He has already. He has
not filed his written statement.
Very well.
Counterclaim.
Very well. Let us take a situation.
Yes.
Plaintiff may choose to file an additional written statement to the counterclaim of a defendant.
May not. Yes.
May not.
May not.
If it's may not, situation is otherwise.
Then, my lord, stopping here for a moment, that doesn't curtail, my lord, the defendants who are there to file its own defense against the statement in counterclaim. A statement can go against the co-defendant.
No.
But that's why, my lord, 6G clears the same rule of written statement would apply. There would be no deviation. There would be no deviation.
Show me the law. Any further law you want?
23, my lord. Kindly read, sir. Paragraph 23. Replication, though not a pleading, as per Rule 1 of Order 6, is permissible with the leave of the court under Order 8, Rule 9 CPC, which gives a right to file a reply in defense to set up or counterclaim set up in the written statement. However, if filing of replication is allowed by the court, it can be utilized for the purpose of calling out issues. But mere non-filing of replication would not mean that there has been admission of facts pleaded in the written statement.
That's right.
This is where I am. But if I have a right in a counterclaim, because I'm a party in the counterclaim, I cannot be said, just because a prayer is against the plaintiff, I am not a party. If I am a party, Milord, I have a right to come up by way of
a party.
Milord, kindly records that. I will end here. Kindly records I am not a party in the counterclaim.
No, I don't know. I don't know the counterclaim.
That's why I'm taking my lord to the counterclaim written statement of the defendant number 3.
Yes, but you show me that you have a right to file a written statement against a counterclaim of a defendant.
Well, this is exactly 23 is. Milord,
trial of an election
from pleading.
Trial of an election petition is not same as that of trial of a regular civil suit.
Absolutely correct. The procedure of Civil Procedure Code will apply. Milord, in dealing with that, Supreme Court deals with Milord Order 8 Rule 9. Explains Order 8 Rule 9. Now, Milord, in explaining Order 8 Rule 9, the Honorable Supreme Court says, or Milord, the provision says, why do I say Honorable Supreme Court? The provision says, Milord, every defendant under Order 8 has a right to file its defense. Milord, it is immaterial what defense he is filing.
And who is taking?
Who is taking? It's immaterial. I have a right to file a defense. Milord, here is particularly a case where I file a defense qua, Milord, his stand which is going against me. The reliefs may not be attracted to me, but the stand, Milord, the averments in the Milord written statement is against me. So, Milord, qua that, Milord, I have a right
there will be a decree when you will be granted an opportunity to file an additional written statement. When there will be the possibility of decree against you. So, on the claim of a written statement of a defendant, against a co-defendant, you are suggesting court will pass a decree on the prayer of
Lord, I am not
defendant
suggesting,
against the defendant.
Lord, what will be the ultimate result? I am not suggesting at this interlocutory
So
stage.
I have to keep that
Lord,
in
I am suggesting, Lord, today my right to file pleadings.
Pleadings to what?
Pleadings to, Lord, a stand taken by a defendant. Lord,
All right.
kindly relies on paragraph 25 also.
Yes.
Of this judge. Though the High Court, while dealing with an election petition, exercises power under CVC, those powers are subject to the provisions of the 1951 Act and any of the rules made thereunder. In consequence, the general power of amendment of pleading or grant of leave to file replication, as is otherwise available to court under Order 6, Rule 17 or Order 8, Rule 9 CPC, is limited by the provisions of 1951 Act and the rules made thereunder. For example, subsection 5 of 86 of 1950 provides that the High Court may allow the particulars of any corrupt practice alleged in the petition to be amended or amplified in such manner as may, in its opinion, be necessary for ensuring a fair and effective trial of the petition. But it shall not allow any amendment of petition which will have the effect of introducing particular of corrupt practice not previously alleged in the petition.
All right.
So, my lord, from this I say, my lord, for effective adjudication and to adjudicate the issue in the trial, my lord, this pleading is necessary. For which, my lord, I am filing this additional subsequent pleading or whichever term, my lord, replication, whatever terminology.
Nomenclature, I don't mind.
Yes. So, my lord, what this, my lord, today, if I can satisfy, my lord, why this subsequent pleading is required? My lord, I humbly beseech this power of granting leave, my lord, comes in. My lord, there is no restriction. Restriction is I have to satisfy, my lord, this leave is required. My lord, to this, my lord, I need to take, my lord, to the facts. My lord, if my lord
No,
says,
I don't require facts.
the
On
law is on this.
I want to. I will deal with on law whether you have
Law
a
is
right
this,
or
my
you
lord.
don't have a
I
right.
have a right, qua the facts, to bring on additional pleadings against, my lord, written statement as well. Because the exception is, my lord, only when it is not against only counterclaim or a set off, but even against a defense, then a leave is required. But since there is a counterclaim, on record, I have an alternative argument and an additional argument. Today, my lord will not only, my lord, allow, but law permits me, my lord, to use a defense against that counterclaim, though, my lord, there is nothing against me because I am a defendant in that counterclaim. I am a defendant in that counterclaim vis-a-vis the plaintiff. I may be a pro forma defendant. My lord, law kindly, I learned other fights, other from learned friends.
So on the counterclaim being raised by one defendant against if a co-defendant is mentioned there, that co-defendant becomes another defendant against that co-defendant.
I have a right to file a defense.
All right. These are your submissions.
These are my submissions on
Give
law.
that book.
বইটা দিলাম দর্শক উড়িষ্যা
Oh, I have. Yes.
Lordship will kindly
Make your
grant me
submission.
leave so that my senior can take over.
Huh?
Lordship will kindly grant me leave so that Mr. Dotto can take over.
Yes, make your submission.
Well, this application.
Give about this book and give also to him and one copy, Xerox copy to him. Give a Xerox copy of that judgment.
I have an extra copy.
Giving.
Scan করে নিলে scan করে নিলে সুবিধা হবে। My lord, this application according to me is not maintainable.
Come back. 5 minutes leave and
yes.
My lord, according to me, this application itself is not maintainable. I will show, my lord, from the provisions of Order 8 that it is only a plaintiff who has the right to file an additional written statement to the counterclaim that may be filed by a defendant in a suit. Lordship was giving an example that there may be a suit by a plaintiff where there are 10 defendants. My lord, what my friend on the other side is arguing, if this proposition is accepted, if there are, my lord, 5 counterclaims, my lord, this would give rise to.
Absolutely. Then 15 defendants will have to file their.
That's right.
Original statement. Trial within the trial.
And this is, my lord, recognized here also in Order 8 itself. Kindly takes, my lord, Order 8. Few provisions I want to take your lordship through. This will, my lord, make the position clear.
Order 8. Which are the provisions?
My lord, I want to rely upon Rule 1, Rule 6A, 6B, 6C, 6E, 6F.
Rule 1, then
6. Rule 1, 6A.
Then 6A.
Yes. Then 6B and 6C.
Yes.
6F, 6G, and 9. Rule 9.
Yes.
I missed one. My lord, possibly 6E would also be necessary just for completion.
Yes.
Now, my lord, kindly takes order 8, rule 1.
Yes.
Defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense. Provided that where defendant fails to file the written statement, this is for, my lord, the extended timeline, not necessary. So it is really the defendant who is filing a written statement to present his statement of defense to the allegations contained in the plaint. Now kindly comes to, my lord, rule 6A.
Yes.
Counterclaim by defendant. A defendant in a suit may, in addition to his right of pleading, a set off under rule 6, set up by way of counterclaim against the claim of the plaintiff any right or claim in respect of a cause of action accruing to the defendant. Kindly marks this expression, cause of action accruing to the defendant against the plaintiff. So it is an independent cause of action of that defendant who is filing a counterclaim along with his written statement, and that cause of action is against the plaintiff, either before or after the filing of the suit.
That's not material.
Yes. Now, my lord, kindly comes to 6B. Counterclaim to be stated where any defendant seeks to rely upon any ground as supporting a right of counterclaim, he shall in his written statement state specifically that he does so by way of counterclaim. C. Where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but in an independent suit. Now, I am pausing here for a moment. There is a provision which recognizes that this counterclaim can be tried as an independent suit. Then who would be the parties to that independent suit? It is that defendant who brings that counterclaim, becomes a plaintiff, and the plaintiff here becomes the defendant. So there is no other party to that suit. And that action will be tried as a separate cause. That provision is, my lord, that according to me, CPC recognizes in 6C. I'll read it once again. Where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but in an independent suit, plaintiff may at any time before issues are settled in relation to counterclaim apply to the court for an order that such counterclaim may be excluded, and the court may, on the hearing of such application, make such order as it thinks fit. That situation has not come up yet. Lordship is not faced with an application from the plaintiff that treat this counterclaim as a separate suit. What if this application comes?
That is between the plaintiff
and that defendant.
That
very defendant, my lord. Yes.
Next.
Then, my lord, 6C. Default of plaintiff to reply to the counterclaim. My lord, no other default is recognized. It is only default. My lord, 6E. It is only the default of the plaintiff that is recognized in, my lord, CPC. If the plaintiff...
Wait. Yes.
If the plaintiff makes default in putting in a reply to the counterclaim. So, right to put in a reply is of the plaintiff. Default is also recognized that of the plaintiff, not of any other party. Why? Because of the preceding provision that it is only between that defendant and the plaintiff. If the plaintiff makes default in putting in a reply to the counterclaim made by the defendant, the court may pronounce judgment against the plaintiff in relation to the counterclaim made against him or make such order in relation to the counterclaim as it thinks fit. I read, my lord, 6E. 6E I just read. Now kindly takes, my lord, 6F. Relief to defendant where counterclaim succeeds. Where in any suit a set-off or counterclaim is established as a defense against the plaintiff's claim, and any balance is found due to the plaintiff or the defendant as the case may be, the court may give judgment to the party entitled to such balance. This expression party used here is, my lord, que, my lord, the plaintiff and the defendant in respect of the counterclaim, not anybody else, not a co-defendant.
You just didn't generate.
Absolutely. Then, my lord, 6G, I said, rules relating to a written statement by a defendant shall apply to a written statement filed in answer to a counterclaim. That is a general provision, my lord. Same principles would apply. And then 9, subsequent pleadings which he is also relying upon. But according to me, the interpretation of my learned friend is not correct. No pleading subsequent to the written statement of a defendant, other than by way of a defense to set off or defense to counterclaim. I am reading it like that. Other than by way of a defense to set off or a defense to counterclaim shall be presented except by leave of the court. Now, this defense to counterclaim is of the plaintiff, and counterclaim is of the defendant number 3 in this case. The applicant has no business to, my lord, deal with the counterclaim of the defendant number 3, where he is a co-defendant in this suit. Because of the, my lord, preceding provisions also, which suggest that a co-defendant who has a counterclaim against the plaintiff, that is a separate action between that defendant and, my lord, the plaintiff. Therefore, my lord, his argument.
Another fundamental thing is, if that is accepted, then trial within the trial.
And suit within the suit.
That means trial within the trial.
Yes.
Next.
And upon such terms as the court thinks fit, but the court may at any time require a written statement or additional written statement from any of the parties and fix a time of not more than 30 days for presenting the same. This is restrictive in the sense it is, my lord, dealing with the, my lord, right to present, my lord, a subsequent pleading. What is that subsequent pleading? If there is a counterclaim, there can be an additional written statement. By whom? By the plaintiff, not by a co-defendant who wants to contest that. So, my lord, this application, and kindly sees the prayer, my lord. Rejoinder is not something which even the CPC recognizes.
Let's not be too technical on
Very
that.
well.
I accept it as an additional.
Very well. My lord, he says rejoinder and written statement. I proceed on the premise it is additional written statement.
Yes,
he has no right as a co-defendant to file an additional written statement. Now, the 2024 judgment which he relies, I did not get a chance to go through that book. Mr. Mukherjee has read it. Kindly permit him to distinguish that. I will, my lord, distinguish, my lord, the other judgment, the second judgment, which is reported in 2024 9 SCC 353. My lord, he relies upon paragraph 23. First of all, my lord, this is, my lord, in respect of an election petition. Election petition, my lord, yes, it says that when it reaches the trial, provisions of CPC will apply.
Mutatis mutandis.
Yes. That is there in the EP rules also.
EP Act also, 1951 Act.
51 Act read with the 67 rules.
67 rules.
Well, 23 is what he placed. I will read 23 because this, according to me, I don't know why he is relying on this. It does not come to his aid. Replication, though not a pleading as per Rule 1 of Order 6, is permissible with the leave of the court under Order 8, Rule 9 of CPC, which gives a right to file a reply in defense to set off or counterclaim set up in the written statement. But nothing more or no addition is made by the Supreme Court than what the statute already provides and recognizes. However, if filing of replication is allowed by court, it can be utilized for the purpose of culling out issues, but mere non-filing of replication would not mean there has been admission of the fact pleaded in the written statement. My lord, that is also a settled position. How come, my lord, how this, my lord, paragraph of the reported judgment aids, my lord, my learned friend's argument that an application by a co-defendant to file an additional written statement to a counterclaim filed by another co-defendant can be entertained or allowed? According to me, my lord, to my understanding, this is not coming to his aid. And the provisions are itself very clear. They suggest that it is only that defendant who has a right and against the plaintiff, and plaintiff has a right against that defendant. Nobody else. If it can be tried, well, kindly visualize, I file an application as a plaintiff invoking that provision.
Read that book.
Permits Mr. Mukherjee, my lord.
I don't mind. Yes, Mr. Mukherjee.
Lordship, if your Lordship does not have the copy of the facts of this case is completely different than what we have here. It is a money suit which was claiming money from a defendant, and there was a preliminary objection raised by the defendant that the plaintiff is not entitled to sue the defendant on its own. There was a question of maintainability of the suit. That is why the defendant number 2 was brought into the picture so that the suit can be saved. At that stage, the defendant made an application to amend his written statement, not to put in any new ground or to add, to file a written statement in rejoinder to a counterclaim. It was only to amend his written statement, and the case here, which my learned friend is relying on, does not apply in the facts of this case. It was rejected, and only then it was carried up in appeal, and it was decided whether it will be allowed Order 8 and Rule 9, whether when new pleadings are set out, whether the written statement could have been amended or not, that was decided in this case. The defend numbers 2 was brought into the picture to save the suit. That is the only distinguishing factor. It does not apply in the facts our case at all.
These are your submissions. I'm coming within 5 minutes. You will distinguish or whatever, but no factual submissions on law. Then I will deliver my judgment here and now. Yes.
My lord, one last minute, my lord. Just, my lord, to add what my junior had said to that judgment. This was, my lord, an application under Order 1, Rule 10(2), which was filed by the plaintiff in his suit to implead another defendant, defendant number 2. That application,
that
that judgment, Orissa, that, my lord, was allowed. And then the defendant number 1 took out an application for amending his written statement, because that Order 1, Rule 10 was allowed. The trial court rejected that application. The High Court on revision said no, this was important because of 2 grounds. Defendant number 1 took one of the ground that I received a summons after, my lord, this plaint was amended, so I have an opportunity to file a written statement. And the substantial point which the defendant number 1 wanted to raise was a point of jurisdiction, in the sense that plaintiff and the defendant number 2 constituted a firm which was unregistered. It was hit by Section 69 of the Partnership Act. Second, there was a contract between the plaintiff and the defendant number 2 which was void under one of the state acts. These were the 2 points he wanted to introduce after the impleadment of defendant number 2, which was rejected by the order impugned, which was subject matter of challenge.
Written statement was
His
allowed
written statement
to
was
be
allowed.
amended.
Yes. For
Finally, amendment.
Finally, amendment after defendant number 2 was introduced as a party. This was, my lord, the factual.
That's very short reply. My lord, my learned senior friend has argued that in counterclaim, plaintiff has only right to come up by way of a defense. Well, other defendants who are parties though to the suit, but has no right to come up by way of defense. Now, my lord, there are twofold arguments I have made. I am not prolonging it. My lord, in reply, I will just submit 2 things. My lord, if that be so, my lord, in a cross suit, which is a counterclaim, my lord, the other defendants, my lord, against whom pleadings are there, my lord, and the prayer is my lord looking into, because my lord is not going to the facts, but in the prayer, my lord, he says, as per paragraph such and such, I am entitled to claim such and such. So, my lord, as per this paragraph, he says, defendant number 1 and plaintiff both are liable to pay damages to me. This is the contention, both sole and both.
He may prove against one, he may not prove against other.
Well, I'm just replying.
I'm
not going into facts. Now, my lord, in this situation, my lord, my reply is, my lord, this es judam generis, which my lord is saying parties, and my lord, order 8, rule 9, any parties, my lord, is not equal. That's why, my lord, replication, additional written statement, rejoinder, all these terms are taken to be synonymous, while Supreme Court is analyzing and visualizing the scope of Order 8 Rule 9. My lord, it's not one single Order 8 Rule 9 which restricts, my lord, and exhausts itself, my lord, up to filing of a written statement. My lord, it is wide open on the discretion of the court to allow a party to deal with certain substantial statements to which he may be affected. My lord, this is Order 8 Rule 9. The object and ratio.
Thank you, sir.
And my lord, this judgment, my lord,
he will take that to deal with.
My lord, only thing, my lord, I will just reply to this judgment, to his submission. My lord, factually, my lord, what he has stated is...
No. You cannot have a right to reply on this.
To this judgment. My lord, his argument.
It is whatever you have done. He has
my lord, I have just
tried to distinguish, that's all.
Yes.
No further.
My lord,
here again, no further replication. No further replication.
There is another application, G8, where we would seek 2 weeks extension to put in our affidavit.
What is that for?
For filing written statement.
Huh?
Another defendant who has taken out an application for leave extension of time to file written statement.
There you want to file your affidavit in
There was a
opposition.
direction. I am seeking an extension.
All right. Ask your junior to be here. We shall pray. Come on.
judgment দেবে স্যার
আসুন আগেরটা কি বলেছিলাম কিছু বলে গেছি এটা মাথার উপর ইনরে বলে বলেছি তো হ্যাঁ 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 ঠিক আছে ঠিক আছে এটা ফ্যাক্সে লিখুন ফ্যাক্স মাথায় মাথায় ফ্যাক্স দিয়ে দিন The plaintiff has filed a suit against how many defendants? Come on, show me the plaintiff. The plaintiff has filed the suit against
5 defendants.
again
5 defendants. Fifth is being
5 individual defendants.
fifth being the pro forma.
Fifth defendant is the pro forma.
5 defendants. Full stop. The fifth defendant is the pro forma defendant. The present applicant is the
My lord, defendant number 1, my lord.
is the first defendant. Full stop. Since the who has filed counterclaim?
Number 3.
Since the third defendant has already filed its written statement containing a counterclaim, has filed its written statement containing a counterclaim. Full stop. Mr.
Kushal Chatterjee, my lord.
Kushal Chatterjee, learned counsel, appearing for the first defendant applicant, submits. Now, refers to the provisions laid down, the provisions laid down under Order Roman 8 of Code of Civil Procedure Roman 8, Order Roman 8 bold, Code of Civil Procedure 1908, bracket for short CPC, and submits that provisions are made for filing a counterclaim by a defendant. Poster. Specifically relying upon Order 8, Rule 9. Rule 9, specifically relying upon Rule 9 under Order 8. Rule 9 under Order Roman 8 of CPC. Mr. Chatterjee submits that no pleading subsequent to the written statement of a defendant, other than by way of defense to set off or counterclaim, shall be presented except by the leave of court. But the court may at any time require a written statement or additional written statement from any of the parties and fix a time of not more than 30 days for presenting the same. Paragraph. According to Mr. Chatterjee, learned counsel, the expression quote unquote bold parties used under Rule 9 includes all the parties to the suit. Poster. He submits, even if a co-defendant raises a counterclaim which is directed against another defendant, comma, such another defendant shall also be permitted to use an additional written statement as against the counterclaim raised against it, directed against it. First. In support, he has placed reliance upon the following judgments. Colon A, small a. in the matter of যেভাবে আমি লিখি এবার বকুনি দেবো যদি ঠিক না হয় যেভাবে আমি লিখি in the matter of bold italics আসুন লিখুন এই চন্দ্রকিশোর ভার্সেস বাবুলাল দেখে দেখে লিখে নিন রিপোর্টেড অ্যাক্ট ঠিক আছে এআইএ 49 1949 উড়িষ্যা 77 আর বি হচ্ছে এটা এই নুরুল ভার্সেস নাহাগ্রাম রিপোর্টেড অ্যাক্ট 8 দেখুন প্যারাগ্রাফ reported act. In the light of the above submissions, Mr. Chatterjee prays that the first defendant should be allowed to file its additional written statement in answer to the counterclaim, alleged counterclaim raised by respondent number, defendant number 3, paragraph. Submissions. এটা সাবমিশনস হয়ে গেল একটা একজনের হয়ে গেল আচ্ছা আমি করে দেবো ওটা পরে সাজিয়ে দেবো আপনি লিখুন প্যারাগ্রাফ par contra Mr. Rajarshi Datta learned counsel with Mr. Sharbojit Mukherjee learned counsel appearing for the plaintiff referring to the various provisions from Order Roman 8 of CPC submits that the counterclaim, the expression counterclaim, quote unquote, is well defined in the code. It is only between the plaintiff and defendant, oblique defendants. If a defendant in its written statement submits a counterclaim in answer to the plaint, which is directed against the plaintiff, comma, in answer to the plaint, which is directed লেখার দরকার নেই plaint, comma, only then the plaintiff would have an opportunity to deal with the counterclaim by filing an additional written statement. More specifically, relying upon the rules 6 capital A to 6G and then rule 9 to order Roman 8 of CPC, Mr. Rajarshi Datta Learned Counsel submits a more specifically take a paragraph. that the expression parties used under Rule 6 to Order Roman 8 should be understood and read in the light of the expression counterclaim as explained and mentioned and defined under Rule 6 itself. Rule 6 capital A itself. And not beyond that. Therefore, when a counterclaim has been raised by a defendant in answer to plaint, it is the plaintiff only who has a right to file additional written statement. A co-defendant has no right to file additional written statement against a counterclaim, if raised by another defendant. Paragraph. While dealing with the judgments cited on behalf of the first defendant applicant, Mr. Rajoshi Dotto Learned Counsel submits as follows. Niche A. In the matter of Chandrakishore Das, Supra, it was a case where the proceeding emanates for addition of party after the plaint was allowed to be amended. Full stop. And ultimately, the written statement was allowed to be amended. By the defendant after amendment of the plaint. This is not the case in hand. Full stop. Paragraph B, subparagraph B. In the matter of Nurul Hasan, Supra, this was an election petition. The law is well settled that an election petition is not instituted through a plaint, but by way of a petition in terms of the statutory form prescribed under the relevant rules and relevant statute and rules. Full stop. However, the procedure for hearing of such election petition, as adapted under the statute and the connected rules, that the same should be heard following the procedure of hearing of a trial of a suit. In the instant case, a simpliciter plaint has been filed and the defendant number 3 has raised its counterclaim through its written statement. Full stop. Therefore, the ratio in the said judgment has no application. Paragraph. Mr. Datta further submits that a co-defendant in law is not permitted to use an additional written statement against a counterclaim raised by another defendant in the same suit, as there cannot be any scope for trial of the claim and counterclaim in between the defendants. Paragraph. In the light of the above, Mr. Datta submits this application is totally frivolous and without any merit and should be dismissed. Paragraph. Decision. After hearing the submissions, after hearing the rival contentions of the parties and on perusal of the materials on record, it appears to this court that the plaintiff has filed the plaint, full stop. The reliefs and nature, the reliefs, nature or the subject matter of the plaint is not relevant to be discussed for the purpose of adjudication of the instant application. The admitted fact is also that the defendant number 3 has filed its written statement lodging a counterclaim against the full stop. The first defendant has already filed its written statement and now seeks to file an additional written statement and praying for leave through the instant application. Paragraph. Rule 6 capital A of Order Roman 8, Order Roman 8 of ওখানে অফ হবে না, দুটো অফ শুনতে খারাপ লাগবে। Rule 6 capital A 2 Order 2 Order Roman 8 of CPC deals with the provisions for counterclaim. Full stop. It says that a defendant in a suit may, in addition to his right of pleading, is set off under Rule 6, set up, by way of counterclaim against the claim of the plaintiff. Any right or claim in respect of a cause of action accruing to the defendant against the plaintiff either before or after filing of the suit. Therefore, the expression counterclaim is restricted by the statute in between the plaintiff and the defendant. Sub-rule 3 to rule no the sub-rules to rule 6A, capital A, state that such counterclaim shall have the same effect as a cross suit, so as to enable the court to pronounce a final judgment in the same suit, both on the original claim and on the counterclaim. It further provides that the plaintiff shall be at liberty to file a written statement. এই সব ঠিক যাচ্ছে তো? অসুবিধা হলে আমার থামিয়ে দেবেন। In answer to the counterclaim of the defendant, and the counterclaim shall be treated as a plaint and governed and shall be governed by the shall be treated as a plaint. Where a defendant seeks to rely upon any ground as supporting a right of counterclaim, he shall, in his written statement, state specifically that he does so by way of counterclaim. The rules further provide that where a defendant sets up a counterclaim, the plaintiff may have a choice, either the same to be tried as a counterclaim or as an independent suit against the plaintiff. In the event a case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim may nevertheless be proceeded with against the plaintiff, set up by the counterclaim, set up by the defendant, set up by the defendant, set up lodged by the defendant, may nevertheless be proceeded with against the plaintiff. Against the plaintiff. If the plaintiff makes default in putting in a reply to the counterclaim made by the defendant, the court may pronounce judgment against the plaintiff in relation to the counterclaim made against it. All these provisions laid down under Order 8 of CPC unambiguously and without any doubt establish that a counterclaim would only be there in between the plaintiff and defendant and not in between the defendants. Poster. Paragraph. The law is well settled that the previous provisions of the statute, when connected with the later part of it, have to be read Eugesdem generis, has to be read by applying the doctrine of Eugesdem generis. EU, JES, DEM, generis. ফোন আছে না, গুগলে দেখে নেবে, ফেসবুক না দেখে এটা দেখবে, চলো পেয়ে যাবে Eugesdem generis. Applying the said doctrine, this court is of the considered view that when the expression parties kothata bold italics, used under Rule 9 to Order 8 should be understood. It should be understood and construed in the light of the previous provisions of the same order under the CPC. Accordingly, this court is also of the firm view that the expression used parties under Rule 9 to Order 8, insofar as counterclaim is concerned, has to be read, construed and understood between the plaintiff and the defendant and not between the defendants. First paragraph. The facts in the matter of Chandrakishore Das Supra is totally different. Full stop. The fact of addition of parties or the amendment of written statement which were there are not the facts in the instant case. In the instant case, the applicant defendant number 1 simply wants to file an additional written statement in reply to the alleged counterclaim raised by the defendant number 2. Defendant number 3. Therefore, the ratio decided in the said judgment has no application in the facts of this case. Paragraph. In the matter of Nurul Hasan Supra, it was an election petition. In which the Honorable Court had observed as under. Set out para 25. Court para 25. Court 1. Naki, ki likhcho? Huh? Court 1. Full stop. Paragraph. From the above quoted paragraph, it appears that the procedure for trial in an election petition is prescribed under the relevant statute, though the procedure adapted is that of hearing of a suit. But the procedure for trial of an election petition cannot be equated with a procedure of trial of a regular constituted suit, civil suit, as in the instant case, where defendants are, where under the law defendants are permitted to file written statement with their counterclaim, if any. Therefore, the said judgment in the matter of Nurul Hasan and the ratio decided therein would not apply in the facts of this case. Paragraph. In the event the contention of the applicant is accepted and the defendant number 1 is permitted to use an additional written statement in response to the counterclaim lodged by the defendant number 3, there will be trial within the trial of a single suit, in a single suit, in between the defendants, this is not permitted in law. Paragraph. In view of the foregoing reasons and discussions, this court is of the firm and considered view that this application is, the instant application is totally frivolous, harassive, and deploy to adopt a dilatory tactics to avoid the trial of the suit, if possible. Paragraph. Accordingly, this application, the instant application being IAGA COM number 7 of 2025, being totally devoid of any merit, stands dismissed with cost assessed at rupees 10,000 to be paid. The commercial suit, sir, and this is a frivolous application. I have heard that it's a frivolous application. 5,000 in favor of the state legal services authority. Full namta ki? Search it out. State legal
services.
SLSA.
State Legal Services Authority,
West Bengal. Positively within 7 days from date. And shall produce the money receipt to the learned advocate on record for the plaintiff. Full stop.
West Bengal State Legal Services Authority. West Bengal State Legal Services Authority. This is
West Bengal State Legal Services Authority. West Bengal State Legal Services Authority. Full stop. Dismiss করে দিয়েছি, মিটে গেল। চলো।
The cost may be some reduced, my lord. 5,000, my lord. It's a government company, my lord.
Go up. Lordship is very kind.
And the time period might be
What for?
For the paying the cost, my lord, 7 days, might be my 14 days time.
All right, 15 days within 2 weeks.
Out of 2 prayers, 1 prayer granted, enough.
আচ্ছা এরপরে তো জিএ আরেকটা IAGA
8 of 2025.
of 2025. He is paying
2
for
weeks, only
extension
2 weeks.
to file opposition. Paragraph. This is an application. আচ্ছা ওইটাকে কিন্তু এটা জাজমেন্ট হিসেবে আপলোড করে দেবে, J2 এবং জাজমেন্ট হিসেবে আপলোড করে দেবে পুরোটাই, একটাই তো অর্ডার।
This should be separate order because otherwise it will come with that judgment.
So how does it matter?
Very well.
How does it matter? You will not obey that portion?
No, of course. Of course.
Better don't obey, it will be compensated. The cost will be compensated doubly to him. কি বললাম? G8 এটা কি সিরিয়াল নাম্বার কতই আছে?
9.
9 আর আগেরটা কত দিলাম?
8.
আগেরটা 8 দিলাম, তাহলে সেপারেট করে দাও, ওদেরও দেখতে ভালো লাগবে। আমি তো ছিলাম ওদিকে না, কি বললাম? 9 একটা অর্ডার করো। This is an this GA blah blah নম্বর বলো বাবা।
GA8 of 2025.
IAGA COM 8 of 2025 is an application filed by the
Defendant.
second defendant seeking an extension of time to file written statement beyond 30 days but within 120 days. To file written statement beyond 30 days but within 120 days as provided under the amended provisions of Order Roman 8, Rule 1 of CPC. Full stop. On the prayer of Mr. Sarvajit Mukherjee, led by Mr. Rajarshi Dotto, Learned Counsel, time to file affidavit in opposition stands extended till আজকে কত?
13th.
December 16, 2025. Affidavit in reply, if any, thereto shall be filed by January 14, 2025. 2026. Growing old, I cannot proceed. 2026, full stop. The matter shall, the application shall appear under the heading Chamber application for final disposal in the monthly list of February 2026.
Grateful.
Thank you. Sorry.
I understand the situation.
Sorry.
May I take back the
Of course. Written statement.
copy of the written statement?
Oh, acha. Thank you.
That's good.
But very sorry. Better in the next time.
My lord, I am appearing on behalf of the plaintiff led by Mr. Shuman Kumar Datta. Lord, in this matter, my witness was in the box. Cross-examination was partly done. He is there present in the court.
What to do? How to?
Learned friend.
No, because I have to read the plain, read the written statement. I have to.
How will your lordship appreciate?
How many witnesses are there for the plaintiff?
My lord, I believe this will be the solitary witness. We may, my lord, tell your lordship, maybe another. I do not know, perhaps not.
And your?
Possibly one. Subject to, of course, what their witnesses.
You have to file evidence on affidavit then.
His witness, my lord, was examined in chief in court, but I can do
My
it
lord,
on
this is
affidavit,
a
my lord.
transfer suit. This was originally filed in the regular
Transfer suit.
division.
Very well.
Transfer suit.
Now,
So
if you
that
agree,
was
then what is the provision?
Affidavit.
Evidence on affidavit. Show me the yeah.
my lord, with respect of this,
Then
my lord,
written statement.
with respect of my lord, this petition, the plaintiff's witness number 1, my lord, that has been done in the box.
That's right. So now the second defendant, if they agree, they can come up with an evidence on affidavit.
Yes, yes, that's
His second witness can also do the same.
if at all
If at all.
required.
And why should we waste time here also? It can be done by your commission.
I don't think we should have an objection to that.
We should not have.
Huh?
We should not have, but this is not a, my lord, very. If your lordship observes that, definitely we have to.
Lordship wants to see the witness and the witness's demeanor, then we can do it in front of your lordship. But I leave it to your lordship.
Unnecessary
I
waste
know, I
of
know,
time.
I know. I bowed out to that.
Show me that provision. The witness in commercial, the amendment made.
আর জিজ্ঞেস করছেন আর বলছেন যে আমি এখানে টাইম ওয়েস্ট করবো না ক্লেমটা আড়াই কোটি মতো ক্লেম কি বলবো আমি কি নট আই এম লেড বাই মিস্টার
এভিডেন্সটা অ্যাফিডেভিটও দেওয়া যেতে পারে।
হ্যাঁ দ্যাটস
পারে না পারার তো কিছু নেই।
প্রভিশন সিপিসি দাও কমার্শিয়াল কোর্স witness.
But the rest of the this can be concluded because he's in the verge of conclusion.
No, yes, I don't mind. But before that, I have to read the plaint, read the written statement, because I am absolutely in the midst of soup. So,
told your lordship on the last occasion that these are commercial suits.
Huh?
So these are commercial suits.
No, that's all right. But still, I want to see the plaint, the documents,
Yes.
and written statement.
Yeah.
Order 16.
No, my lord, I believe it is. Commercial Code Sector though. These Well, if your lordship comes to amendment to order 18.
Yes.
Order 18 after Rule 4.
After Rule 4.
The affidavit, this is what has been inserted after.
No,
Rule.
I have
Oh.
not meant.
Well, your lordship will see what has been inserted. Affidavit of evidence of all witnesses whose evidence.
In which rule you are? The affidavit of evidence of all witnesses whose evidence is proposed to be led by a party shall be filed simultaneously by that party at the time directed in the first case management hearing. So the evidence on affidavit is a must in the commercial law.
Unless there is a amendment to the original side, unless there is an amendment to our original side rules. Because it will come back to your lordship that the evidence by way of affidavit was introduced in the civil procedure code prior to the commercial. There will not the dispute. Some courts followed the practice and some followed. And there are judgments of our court which says that the original side rules will prevail.
Absolutely.
But I don't see any mandatory force in this. But
since it is under a special statute, the amendment in view of the operation of a special statute, which is a later one, the presumption that it has taken care of the prevailing rules and statutes. Because I was searching for the proposition whether any consent is required for evidence on affidavit. That the party may say no, I will not. I will only go to the box to the dock. I will not give consent for evidence on affidavit.
But I don't see, Millard.
The power is also given to the court to decide. Kindly see, Millard, Order 19, Rule 4, which has been brought in vis-a-vis the amendment. Court may control evidence.
No, that is on affidavit. Controlled. That is not here. Neither here nor there. Mr. Dutt, what was really troubling me, let me be very candid, that whether if I direct that you do your chief by way of affidavit, that direction is sufficient or parties have to agree. So I find that in view of the special law, later law, and by virtue of that the amendment came, the language is the affidavits of evidence of all witness whose evidence is proposed to be laid by a party shall be filed simultaneously.
That is, my lord, provided there is a case management hearing direction.
Provided?
There is a case management hearing direction.
Yes.
In this case, I don't think there is any such direction. Like, my lord, your lordship will find, your lordship was reading Rule 9(1)(a), shall be filed simultaneously by the party at any time, directing the first case management hearing. That has probably not taken place in this.
I have got one, this.
No. What I want is, my lord, yes, it's there. It's case management hearing is there. My lord, if your lordship reads that same rule, where your lordship found that the party shall be filed simultaneously.
I am only on the thing. Let me be
no, my lord, what is this, my lord?
Let us give a pace to the proceeding. Do it by way of affidavit, so far as chief is concerned. Cross from the dock, and not from the dock, before the commissioner. Get it ripened for hearing. In every respect, court will hear out the matter. Otherwise, Mr. Dutt, I tell you why.
I know, Willard, your lordship is trying to expedite the suits and not waste time on the evidence part.
One and two is the entire commercial court is only one court. Then, including hearing and of suit. So, and as I believe perhaps you also, we all are of contemporaneous time, that a suit hearing cannot be done in a slipshod manner. It cannot be. Whatever commercial and the nature of it, sometimes some devotion has to be there. After all, it is deciding the rights of the parties finally. So, hearing of suit along with all these commercial matters. So, but within that, if this can be expedited.
It can be, Millard. It can be. But Millard, what I was suggesting is this, Millard. Not in all suits because of two reasons. One is, Millard, as I said, Millard, commercial suits or non-commercial suits. Even under non-commercial suits, Millard, under this rule, your lordship has the power to direct the commissioner without the consent of the parties to record evidence.
Under CPC.
Yeah, under that amendment has come in 2002. But Millard, what happens is this, like your lordship has an experience to understand the witness, the credibility of a witness.
The body language.
Very important.
Absolutely.
Now, Millard, the commissioner is not in a position. Commissioner can only record what the party.
That too, he cannot express his mind. How will he express in his report?
Now, suppose I ask a question, the witness pauses, looks this side, that side. Your lordship may remember this, that.
Right, right. No doubt about it.
So, in that case, Millard, commission may not be the right way. But what I am trying to say, insofar as this suit is concerned, this suit where my claim is only 1.5 crores. It's not a humongous amount. The chief has been done because Millard, the previous practice was that everything from the box. Cross already more than 60% has done. So if he can finish his cross, so far as his chief will.
No. In this suit, let me also be very clear to you. In this suit, I will allow the cross to be finished from the dock. Now, if the second witness comes from the plaintiff side, then he will file an evidence on affidavit. No. Just I'm expressing my mind. Then he will file an evidence on affidavit. His cross will be done before the commission. Similarly, his witness shall file evidence on affidavit, whose cross will be done by you before the commission.
I have no objections to that, but thing is that, Millard, there are more powers which is vested in the court subsequently, which my learned friend was referring to, that the commissioner cannot exercise. Millard, like I tell your lordship why. Suppose there are 16 documents between the parties, and I go on asking irrelevant questions on a document which is admitted. Now, Millard, more often than not, the court, even in cross-examination, shuts the witness and says that, look, the document will speak for itself. Why are you asking questions on that? That power is given to the court to curtail the witness. But the commissioner will be helpless, number one, and the cost will go on, and because the commissioner will have 15.
Accepted. But Mr. Dutt, considering the fact that expedition has also to be there.
It's your lordship's discretion, whichever power is with your lordship. Millard,
I tell you, Mr. Dutt, I tell you that.
But Millard, I will request your lordship in cases where there is an interpretation of contract or a will, Millard, these Millard commissions, because I remember, Millard, there was a matter which I was doing, a testamentary matter, and the witness was in the box who had come up for probate of a will after 17 years. And Millard, he went to the box and his body language was very rude because I was asking him questions which he did not have answer. And Justice Morat Sinha was there, and he said to me, Mr. Dutt, you are asking uncomfortable questions to the witness and the witness is losing its temper. And he doesn't realize, but the court is taking a note of it. Millard, that matter, Millard, ultimately went for hearing to Justice Standard. And I could not make the court understand that this man was actually lying from the box because the evidence for nothing was recorded.
No, cannot be.
So, in those matters where, Millard, testamentary matters where, Millard, it's all on the question of facts, Millard, and the demeanor of the witness. Kindly don't send this to commission. Otherwise, my lord, it will lose its.
Not only that, the flavor is also lost. I understand. I understand. But
And at least
considering the
commercial-
practical aspect,
My lord, may I say this, my lord? May I say this? Let him complete his cross-examination.
no, that I said, I will allow it to be completed.
I will show your lordship, my lord, or if your lordship permits me, I will show your lordship the scope of my claim.
You have to. I know nothing.
Yes, I will. In fact, my lord, I can do it also now, so that your lordship will find that the scope, it was a winding up petition that was returned because two letters, according to my client, two letters were not there, where there is a balance confirmation. I had to only prove those balance confirmations. Primarily, this is the question of limitation. My learned friends have taken the point of limitation at an ad interim stage during the pendency of the suit by Order 7, Rule 11. That has travelled up to the apex court, and the apex court has sent it back, saying that it did not rule on the question of limitation, but it said it's a mixed question of fact and law.
Fact and law.
So,
trouble.
Yes. Apart from that, I don't think there is any other point. Is there any other point apart from limitation?
We also have another suit pending against them.
Right, that's all right. You will proceed in your own way.
So if
I
it's
don't
a
mind
question
for
of limitation, that can be.
So very well, let us start.
Let us start. Let us see. Thereafter,
us see.
if your lordship feels that no, the rest should go before the commission, obviously let carry.
No, that is for his witness. That is for his chief. After conclusion of his cross from the dock.
Your lordship will be looking at the plaint, or I should proceed with.
No, I have to.
Yes.
Take it from zero. Take me from zero. As I said, hearing of a suit cannot be done in a slipshod manner.
How are people? তিনটা পাচ্ছি না কোনো এটা কার মামলা তা depositions. এই তো Millard, a very just, well, I'll just give you a lordship.
Yes. 1 second, sir.
Mine. সেটা আমি খালি প্লেটটা প্রেজেন্ট করবো
Just first give me a overall.
Millard, the plaintiff in this suit, Millard, carries on the business of mining and trading.
Take your seat, sir.
Carrying on business of mining and trading.
Take the microphone properly.
Carries on business of mining and trading of iron ore. Now, my lord, the defendant are carrying on business of transporters. They provide rakes and all. Now, my lord, the understanding was by way of correspondence, there is no agreement in writing, that we will pay an advance. Suppose I want to export my iron ore mines and I need rakes. I'll place an order on the defendant for rakes. He will give me a rate, provide me the rake, and the transportation will happen. Now, parties who are carrying on this business till such time, my lord, and since they were carrying on this business, the parties were running an account. Sometimes, my lord, I used to pay an advance of say 10 lakhs. I'm giving an example.
Running mutual.
Yes. Mutual in the sense, my lord, that it was only going from me. It was a continuous account to be.
Going from you,
going from
against which you are receiving the
services. Now, suppose, my lord, I gave him an advance of 10 lakhs, and thereafter, the services which he renders, we agree that it would be carried on for 6 lakhs. So, 4 lakhs remains in his account till such time I need a new rate. This was the understanding between the parties, that as and when I will need a rake, I'll let him know, he will provide a rake, the rates would be discussed, there was no fixed rate. This would be evident, my lord, from the correspondence exchange between the parties, and this is not very seriously disputed in the written statement either. Now, the dispute arose when, my lord, the Supreme Court, my lord, gave certain restrictions on the mining. The business more or less came to a standstill. So, ultimately, we are relying upon a letter of the defendant where they give us a balance confirmation saying that 1 crore 29 lakhs and odd is lying in their account as money paid in excess in advance. So that is the balance confirmation. Now, when we ask for that money, my lord, they say their case is that in anticipation that you will place rakes, we have incurred losses because you have not placed the orders on a regular basis. Be that as it may, my lord, on this basis, since according to us that there was an acknowledgement in writing in the balance confirmation, we filed a winding up application. In that winding up application, my lord, they for the first time say that no, we are not paying this money because we have also filed a suit before the Alipur court where, my lord, we are claiming damages. And this 1 crore 29 lakhs, which is payable.
But no counterclaim.
Not a counterclaim in the.
That's right.
Yes.
So here no counterclaim.
Here no counterclaim. There is no counterclaim. So that 1 crore 29 which was due and payable to you, we have adjusted it, and the balance is what is claimed in the Alipur. That suit was filed before the Alipur court. Now, my lord, before the winding up court, my lord, the court felt that there is a question of limitation involved, relegated the parties to suit. And according to me, the suit was filed on the basis of that observation and the directions given by the winding up court. Now, my learned friend's contention as to limitation is that during the continuance of the winding up petition, there was no self-injunction and the limitation continued, and therefore your claim is barred by limitation. That is one.
But the court granted you leave.
The court granted me leave to.
But the point of limitation was kept open.
Because that was the ground on which the winding
was
kept open. Now, when we filed the suit, my lord, we annexed documents, including their winding up documents relied upon by the parties in the winding up proceedings, the affidavit, the entirety of it, to show that there has been an acknowledgement within the period of limitation, and therefore no part of the claim is barred by limitation.
No, 1 second.
Yes, my lord.
Subject to what you say. One winding up petition has been filed.
My lord.
Which was relegated to suit.
Yes.
Keeping the point of limitation open.
Yes.
So which date has to be construed for the date of counting limitation? because the moment winding up is relegated to suit, is there no section 14 benefit available?
There are two views. One view is winding up is not a
money claim.
Money claim. So therefore, if you have a money claim, money does your limitation doesn't stop. There is another view which says that no, it is a equitable mode of execution. Therefore, section 14 will apply.
Not only that, here one fact that court has relegated to you.
Yes, court has.
The moment court has relegated to you, with the limitation point keeping open, which means court thought it fit. Will it not be construed like this? Court thought it fit.
That this is not an appropriate forum.
This is not an appropriate forum. You have a tribal issue, so you go before the suit court.
I would be arguing that.
Try your point of limitation, but it will be a tribal.
I will be arguing that also, that the court felt that, well, my lord, as if I proceed on the basis that it's an equitable mode of execution, then my lord, ultimately it's a money decree that is being passed. If there are no disputed questions. Now, if the court feels that there is a disputed question, then of course, my lord, I can also argue that I have the benefit of proceeding with the forum. But be that as it may, this is the only question that is involved over here, whether my claim is barred by limitation. And so far as their counterclaim, I have not seen any evidence coming forward. So they have a counterclaim for their damages, but that suit is pending before the Alipur court. So
dependent suit.
This is it. This is all.
So please take me through the written statement. This.
I was waiting for my junior. So it was their golden opportunity to address the court, because presentations of plains, my lord, I have learnt it that way. Seniors is to say, go, this is your opportunity to address the safest. The court will not ask you any questions.
Now written statement of the This it.
Very first relevant paragraph, my lord, is paragraph 2. Suit is barred and or bad under the provisions of Limitation Act, and the plaintiff.
Take the microphone. This one, sir. Yes. Here some acoustic problem is there, and since the fan is running, yes.
Let us start off right with the one of the initial paragraphs of the written statement, paragraph 2. The suit is barred and or bad under the provisions of Limitation Act, and the plaintiff is liable to be rejected and or the suit is liable to be dismissed on this preliminary issue. So that is my first main point which I have urged. And as Mr. Dotto rightly pointed out, my lord, I had filed an interlocutory application also taking this point, which was ultimately dismissed. Although there are findings in my favor in the order disposing of my application under Order 7 Rule 11.
Interlocutory finding doesn't matter.
Yes. But ultimately, the court held mixed question of law and fact, went up to the Supreme Court, and now it's before your lordship to ultimately decide. Apropos the point which had fallen from your lordship, my lord, whether the benefit of...
let's see the plain written statement first. Come on, at page paragraph 3.
Paragraph 3. That the plaintiff as framed does not disclose any cause of action, as the plaintiff has none. The plaintiff does not disclose any right to sue. This is a vexatious litigation which is meaningless and bound to prove abortive. This should not be permitted to occupy the valuable time of this learned court and should be nipped in the bud and or rejected. No decree can be passed on the basis of such a frivolous plaint. Para 4. Without prejudice to the aforesaid and fully relying thereon, the defendant deals with the allegations made in the plaint hereunder. Para 5. The allegations made in paragraph numbers 1 and 2 of the plaint are to the special knowledge to the plaintiff, and as advised, the answering defendant refrains from dealing with the same. Without making any admission thereto, save as aforesaid, all other allegations are denied. Paragraph 6, my lord. With reference to paragraph number 3 of the plaint, the answering defendant states that save what appears from the wagon investment schemes of the Indian Railways, anything contrary thereto or inconsistent therewith are denied and disputed. It is stated that the wagon investment scheme guarantees supply of limited rakes every month. In case indents are not placed for the said guaranteed rakes, the said guaranteed supply lapses for the month. Hence, any commitment or guarantee for supply of rakes has to be backed by minimum consideration, which will be forfeited in case any customer, like the plaintiff, fails to place indents even after an agreement, since the respondent cannot use the said number of rakes committed to its customers during the month, and the said guaranteed number of rakes lapses, resulting in loss of business to the respondent. Save as aforesaid, all other allegations are denied. I just pause here for one small moment. My plaint, my suit filed before the Aleppo court is based apropos my contentions in this paragraph. That there was a minimum guarantee clause. They did not place orders on me for several months, which is why I suffered a loss, and therefore I filed a claim against them, which is pending adjudication before
Which is prior in point of time?
My suit is prior.
Your suit is prior in point of time.
2014.
All right. Proceed.
Paragraph 7. The allegations made in paragraph number 4 of the plaint are denied and disputed. It is stated that the respondent is the logistics service provider. It is denied that the defendant is a general carrier or transporter of goods, as alleged. Save as aforesaid, all other allegations are denied. Para 8. The allegations made in paragraph 5 of the plaint are denied. The respondent guaranteed supply of rakes under the wagon investment scheme to the plaintiff. Save as aforesaid, all other allegations are denied. 9. The allegations made in paragraph 6 of the plaint and various subparagraphs thereunder are denied and disputed. It is denied that there was any agreement with the plaintiff, as alleged. It is denied that any agreement was entered into in or about February 2009, as alleged. It is denied that the defendant agreed to unload or transfer of shipping goods for import or otherwise, as alleged or at all. It is denied that there was any agreement with the plaintiff for transportation of plaintiff's iron ore from any mine to any port, as alleged or otherwise or at all. It is denied that any advance was agreed along with the intents for the rakes requisitioned by the plaintiff, as alleged. It is stated that the plaintiff was required to place advance requisition orders for the railway rakes required by it on a monthly basis, along with a non-refundable advance of the agreed premium for the said rakes, since the defendant would then block the required rakes from its guaranteed allotment under the WIS. It is denied that the parties ever agreed that there would not be any shortage of scarcity in respect of supply of rakes to the plaintiff, or the defendant would continue to supply rakes to the plaintiff as long as the said wagon investment scheme was effective or operational, as alleged. It is denied that there was any agreement with the plaintiff for payment to the defendant for each rake required to transport iron ore, as alleged. It was agreed between the parties that the premium amount would be paid along with the advance intimation, which would be non-refundable in case the plaintiff fails to place requisition for the said rakes, and other charges would be payable for each rake utilized by the plaintiff to transport iron ore to various ports. The contents of letter dated August 12, 2009, being annexure 8 to the plaint, is denied and disputed, since the same is an internal document of the plaintiff and hence cannot disclose any agreement with the defendant. It is denied that the letter dated August 14, 2009, being part of annexure 8 to the plaint, in any way reflects any agreement between the parties, as alleged or otherwise or at all. The said letter is merely an advance order for the month. It is denied that the terms and conditions of the agreement between the parties will appear from or will be evidenced by the course of conduct as alleged, or by any contemporaneous correspondence between the parties as alleged or otherwise or at all. It is denied that the parties did not sign or execute a formal written document due to any cordiality between the parties as alleged or at all, save as aforesaid. All other allegations are denied. Paragraph 10. With reference to the allegations made in paragraph 7 of the plaint, it is denied that the agreement was entered into the plaintiff's office as alleged or otherwise or at all, save as aforesaid. All other allegations are denied. Paragraph 11. With reference to the allegations made in paragraph 8 of the plaint and the various subparagraphs thereunder, it is denied that there was any agreement as alleged. Hence, the question of performance of any alleged agreement by the defendant does not and cannot arise. The allegations made in paragraph 8 and various subparagraphs thereunder of the plaint are matters of record. Anything contrary thereto or inconsistent therewith are denied and disputed. It is denied that the payment for the rakes are supplied by the defendant and utilized by the plaintiff was made on the basis of invoices raised by the defendant on the plaintiff as alleged, or any invoice was raised at the office of the plaintiff as alleged or otherwise or at all. It is denied that the defendant had received payments from the plaintiff at the plaintiff's office or has appropriated the same to its use as alleged or at all. It is stated that the non-adjustable advance payments were received by the defendant at its office along with the advance order by the plaintiff. Save as aforesaid, all other allegations are denied. With reference to the allegations made in paragraph 9 of the plaint, it is denied that the parties maintain a running or continuous account as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. 13. With reference to the allegations made in paragraph 10 of the plaint, it is denied that a sum of rupees 1,20,99,274 or any other sum was due or payable by the defendant to the plaintiff as on March 31st, 2011, or on any other date as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. Paragraph 14. With reference to the allegations made in paragraph 11 of the plaint, it is denied that the defendant had admitted or acknowledged or confirmed that a sum of rupees 1,20,99,274 or any other amount was lying to the credit of the plaintiff in the defendant's books as alleged. It is denied that the ledger account maintained by the defendant evidences or records the indebtedness or liability of the defendant to the plaintiff for a sum of rupees 1,20,99,274 or any other sum as on March 31st, 2011, or on any other date as alleged, or it will appear from the balance confirmation letter dated March 31st, 2011, as alleged or at all. It is denied that any balance confirmation letter acknowledging or confirming any indebtedness or liability to the plaintiff was written by the defendant as alleged. It is denied that the letter dated March 31st, 2011, being Annexure B to the plaint, acknowledges or confirms any indebtedness of liability to the plaintiff as alleged. It is denied that the aforesaid letter was received by the plaintiffs at its office as alleged. Save as aforesaid, all other allegations are denied. Paragraph 15. With reference to the allegations made in paragraph 12 of the plaint, it is denied that at any point of time, any restriction was imposed by the government of Orissa on usage of railway rakes through the methodology of sourcing the same from third parties under the wagon investment scheme as alleged or otherwise or at all. Assuming, without admitting, that there was any agreement, it is denied that any agreement became impossible to perform as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. Paragraph 16. With reference to the allegations made in paragraph 13 of the plaint, it is denied that there was any contract as alleged or any contract was impossible to perform as alleged, or there was any supervening circumstances as alleged or otherwise or at all. It is denied that any agreement stood frustrated or was rendered void by any operation of law as alleged or otherwise or at all, save as aforesaid, all other allegations are denied. Paragraph 17. With reference to the allegations made in paragraph 14 of the plaint, it is denied that the defendant had any notice or knowledge of any contract having become impossible of performance, as alleged or otherwise or at all. Since there was no contract and or agreement, the question of any contract or agreement becoming impossible of performance does not and cannot arise. Save as aforesaid, all other allegations are denied. Paragraph 18. With reference to the allegations made in paragraph 15 of the plaint, it is denied that the plaintiff could not requisition or use the rakes of the defendant, as alleged or otherwise or at all, save as aforesaid, all other allegations are denied. Paragraph 19. With reference to the allegations made in paragraph 16 of the plaint, it is denied that any restriction was imposed by the government of Orissa, as alleged, or the parties agreed to any reconciliation, or that the money found in excess lying with the defendant would be refunded to the plaintiff, as alleged or otherwise or at all. It is denied that any reconciliation of accounts was carried out by the defendant, or a balance confirmation of accounts under cover of an email dated September 28, 2011 was sent to the plaintiff as alleged. It is denied that email dated September 28, 2011, being Annexure C to the plaint, was received by the plaintiff at its registered office as alleged. Save as aforesaid, all other allegations are denied. 20. With reference to the allegations made in paragraph 16 of the plaint, it is denied that any balance confirmation of accounts indicated any reconciliation of accounts between the parties, or the defendant was to refund a sum of rupees 1,20,99,274 or any other sum to the plaintiff, as alleged or at all, save as aforesaid, all other allegations are denied. With reference to the allegations made in paragraph 18 of the plaint, it is denied that a sum of rupees 1,20,99,274 or any other sum was or is due or payable by the defendant to the plaintiff as on March 31st, 2011, or on any other date as alleged or at all. It is denied that the plaintiff had ever called upon the defendant to make payment of any money as alleged. Save as aforesaid, all other allegations are denied. 22. With reference to the allegation made in paragraph 19 of the plaint, it is denied that by letters dated November 16, 2011 or April 30, 2012, being Annexure D to the plaint, or any other date, the plaintiff had called upon the defendant to make payment of any sum as alleged or at all. It is denied that the defendant failed or neglected to pay any sum or any part thereof or interest thereon as alleged or otherwise or at all, save as aforesaid, all allegations are denied. 23. The allegations made in paragraph 20 of the plaint are matters of record, and anything contrary thereto or inconsistent therewith are denied and disputed. Since nothing was due or payable to the plaintiff by the defendant in the notice dated October 3, 2013, being Annexure E to the plaint, was not replied, save as aforesaid, all other allegations are denied. 24. With reference to the allegations made in paragraph 21 of the plaint, it is denied that receipt of the statutory notice under Section 434 of the Companies Act 1956 raises any presumption of indebtedness, whether statutory or otherwise, on the part of the defendant, as alleged or otherwise or at all. It is stated that the defendant was not required to rebut to the alleged statutory notice, as alleged or otherwise or at all, save as aforesaid, all other allegations are denied. With reference to the allegations made in paragraph 22 of the plaint, it is denied that the plaintiff's claim for a sum of rupees 1,20,99,274 or any other sum stands unrebutted or admitted, as alleged or otherwise or at all. It is denied that the plaintiff had any right of recovery of the sum of rupees 1,20,99,274 or any other sum or any interest thereon, as alleged or otherwise or at all, save as aforesaid, all other allegations are denied. Para 26, with reference to the allegations made in paragraph 23 of the plaint, it is stated that the same are matters of record, save as aforesaid, All other allegations are denied. Para 27, my lord, talks about the winding up petition. With reference to the allegations made in paragraph 24 of the plaint, it is denied that the company petition, being CP number 834 of 2013, was disposed of by relegating the same to a suit as alleged. It is stated that the said petition was not admitted, since this honorable court found that the claim of the plaintiff could not have been pursued in December 2013 in respect of a deposit made in the year 2009. Hence, it was held that the said petition was barred by limitation. Save as aforesaid, all other allegations are denied. Para 28, with reference to the allegations made in paragraph 25 of the plaint, it is denied that the plaintiff could not disclose the letters dated March 31, 2011 or September 28, 2011 due to inadvertence or oversight, as alleged or otherwise or at all. It is denied that the Honorable Court is levied that it cannot be assessed as to whether the plaintiff's claim was within the period of limitation as alleged or at all. Save as aforesaid, all other allegations are denied. Paragraph 29, with reference to the allegations made in paragraph 26 of the plaint, it is denied that the letter dated March 31, 2011 or September 28, 2011, being annexures B and C to the plaint, are acknowledgements of indebtedness or liability within the meaning of Section 18 of the Limitation Act 1963 as alleged or otherwise or at all. It is denied that the said documents amount to acknowledgement of liability in writing by the defendant in respect of its indebtedness or liability with regard to the plaintiff's claim as alleged, or before expiration of the prescribed period of the institution of suit as alleged, or a fresh period of limitation is to be computed as alleged or otherwise or at all. Hence, the question of computation of fresh period of limitation does not and cannot arise. Save as aforesaid, all other allegations are denied. 30. With reference to the allegations made in paragraph 27 of the plaint, it is denied that had the aforesaid documents being brought on record were considered by the Honorable Company Court, the company petition would surely have been allowed as alleged or otherwise or at all. It is denied that the defendant could have been wound up as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. With reference to the allegations made in paragraph 28 of the plaint, save what are matters of record and anything contrary thereto or inconsistent therewith are denied and disputed. It is denied that the company petition against the defendant was in relation to the same matter in issue as alleged or otherwise or at all. It is denied that the plaintiff was prosecuting in good faith as alleged, or the plaintiff is entitled to exclusion of the time during which the company petition was pending as alleged or otherwise or at all. It is stated that the relief sought in company petition is different from the reliefs sought in the plaint. In the company petition, adjudication of the defendant as insolvent was sought for, and it was prayed for winding up of the defendant. But in the instant plaint, some alleged money due is sought to be realized from the defendant. Since the reliefs in the two proceedings are different as well as widely divergent, the plaintiff is not entitled to exclusion of time during which the company petition was pending before the Honorable Company Court. Hence, the instant proceeding is barred by limitation. Save as aforesaid, all other allegations are denied. 32. With reference to the allegations made in paragraph 29 of the plaint, it is denied that the plaintiff is entitled to a sum of rupees 2,95,22,230 or any other sum as on March 31, 2016, or on any other date as alleged or otherwise or at all. The particulars as stated in the paragraph under reply are denied and disputed. Save as aforesaid, all other allegations are denied. Paragraph 33. With reference to the allegations made in paragraph 30 of the plaint, it is denied that the plaintiff is entitled to any interest on the sum of rupees 2,95,22,230 or any other sum at any rate as alleged or otherwise or at all. It is denied that the nationalized banks charge interest at a rate not less than 24% per annum as alleged or otherwise or at all. It is denied that the defendant has received money and uses the same without being entitled to do so as alleged or otherwise or at all. it is denied that the plaintiff is entitled to any compensation by way of interest or otherwise on the sum of rupees 1 crore 20 lakh 99,274 or any other sum as alleged or otherwise or at all. It is denied that the plaintiff is entitled to interest under the Interest Act as alleged or any notice has been issued as alleged or otherwise or at all, save as aforesaid, all other allegations are denied. With reference to the allegations made in paragraph 31 of the plaint, it is denied that the plaintiff is entitled to any interest at the rate of 24% per annum or at any other rate on the aforesaid sum on and from April 1, 2016 or from any other date as alleged or otherwise or at all. It is denied that the plaintiff is entitled to any interim interest or interest upon judgment as alleged or otherwise or at all. 35. With reference to the allegations made in paragraph 32 of the plaint, it is denied that the defendant has failed or neglected to make any payment to the plaintiff as alleged or otherwise or at all. It is stated that the demands made by the plaintiff were ignored by the defendant since nothing was due or payable by the defendant to the plaintiff. It is denied that the plaintiff is entitled to any decree for any sum as alleged or otherwise or at all. It is denied that laws of limitation bar no part of the cause of action of the plaintiff as alleged or otherwise or at all. It is stated that the instant proceeding is barred by laws of limitation, save as aforesaid, all other allegations are denied. Paragraph 36. With reference to the allegations made in paragraph 33 of the plaint, it is denied that the plaintiff is a creditor of the defendant as alleged or otherwise or at all. It is denied that the defendant is a debtor or is obliged to make payment of any money as alleged or any money is due or payable to the plaintiff as alleged or otherwise or at all. Hence, the question of making any payment to the plaintiff at its registered office on the principle of debtor seeks creditor does not and cannot arise. Save as aforesaid, all other allegations are denied. 37. With reference to the allegations made in paragraph 34 of the plaint, it is denied that any part of cause of action has arisen within the jurisdiction of this honorable court as alleged or otherwise or at all. Hence, the plaintiff is not entitled to any leave under clause 12 of the latest patent as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. 38. With reference to the allegations made in paragraph 35 of the plaint, it is denied that the plaintiff has paid maximum court fees as alleged. Save as aforesaid, all other allegations are denied. 39. With reference to the prayers made in the plaint, it is denied that the plaintiff is entitled to any decree for a sum of rupees 2 crore 95 lakh 22,230 or any other sum as alleged or interim interest or interest on judgment as alleged or any of the prayers as alleged or otherwise or at all. Save as aforesaid, all other allegations are denied. 40. Save as expressly admitted herein before, each and every allegation contained in the plaint are denied and disputed as if the same are set out hereinafter and traverse seriatim. 41. And the last. It is respectfully submitted that the plaint be rejected and or be taken off the file and or the suit be dismissed.
So this is the balance confirmation, 28th September 2011. Page 14 of the written statement, paragraph 19. Is this the one?
Page 14.
Paragraph 19, page 14, written statement.
Takes the judges to study. One. এটা তো beautiful. PD4
page.
Lord, it would be page 4, 31st March 2011. 5.
Which running page?
28/9/2000. This is at page 6 of the judge's brief. So, serial number 5. It asking about this.
Your lordship is asking about the balance confirmation.
Yes.
That is page 4 of the
4.
judge's brief. No, he is not asking. He is asking about the
March.
Yes. This has been sent to us. And this was sent to us as an attachment
Yes.
I seek one indulgence. Can I be excused, my lord? Can I seek one indulgence? Can I be excused? I have a matter fixed at 3 p.m. where I was continuing my arguments. My lord, the matter can continue, my lord. My junior's there, but the cross-examination, if I can be permitted to do it on the next date, whenever it is fixed.
This Willard was sent to us by way of an email, which is at PD6.
Page
6. কোথায় গেল? এই ledger record গুলো এর সাথেই এসেছিল তো?
This was an attachment to page 6.
At the bottom, your lordship will find PFA. And my lord, your lordship will find the subject EMARS ledger.
কোথায়?
Page 6. Subject attachment EMARS ledger PDF. At the top.
EMARS ledger.
This is the 28th September 2011 mail which your lordship is looking at. So under cover of this mail, that ledger was sent. Millard, what I propose to do, Millard, since your lordship is, and I will prepare, since it's a question of limitation, I'll prepare a list of dates and the exhibits that has already happened. I'll indicate that this letter is exhibit number such and such.
At page such and such.
And I'll give
judge's
the
brief.
question number where it has been exhibited by in the previous quarter. And if your lordship takes it from there, your lordship will have a very clear idea as to the dates, what has already been exhibited, what has been marked, and what is there to be done by them. Because I don't think, Millard, there are whatever I am supposed to prove, I have proved and exhibited. Now, Millard, it's for them to dislodge or if they want to bring in. But thing is this, Millard, so far documents are concerned, almost all documents are more or less admitted because I have, as my disclosure, given the entire pleadings filed before the winding up court. And it has been admitted and accepted by both the parties. So that would be much easier for your lordship if your lordship have it in the form of dates, exhibits, and question numbers.
So now the next task will be, you have to take me to your witnesses chief.
I will do it, Millard. If I can do that list of dates, it will again refresh my memory and I'll do it.
So next day I will go through the chief, so that I can get an idea.
Idea as to how much of it is proved and in what manner.
And then they will start their cross-examination.
My lord.
One thing that I cannot open too many suits at a time.
No, Millard, your lordship said I'll take up, complete, then take the second one. Yes, that's.
At least
The
one has
pleadings.
begun.
The pleadings.
No, one suit has begun. Let's see.
They will all begin slowly. Millard.
Absolutely. Everything has its first day.
Yes. You can come back by next Thursday with I'll come back by next Thursday with the list. Next Thursday
So
with the list of dates.
Whatever.
And
you whatever you want, way you want to proceed, you will proceed. I mean, both of you. Whatever way both of you will want to proceed, you will proceed. I don't mind for that. Ashu. Mr. Shuman Kumar Dutt, Learned Senior Counsel.
Is it your my lord's desire that on the next day the witness should also be present? He is present today also. Or would your lordship first apprise your lordship with the evidence?
No, first that I have to do.
Then my
Now,
lord,
if it takes, let's say, half an hour, then of course the witness, if present, can
then
be
let him be present so that we can make some progress.
your witness. Ashu.
May I take your lordship's leave?
Mr. Shuman Kumar Dutt, Learned Senior Counsel, appearing for the plaintiff, has placed the plaint and has summarized the nature of the suit and the transaction made between the parties. Mr. Rishad Medora, Learned Counsel, appearing for the defendant, has placed his written statement. The record shows, yes, now you please listen to me. The record shows, paragraph, that the examination in chief of the plaintiff's witness has been concluded. Full stop. The learned counsel for the defendant has commenced cross-examination of the same witness, of the said witness, which is in progress. Paragraph. At this juncture, the suit has been taken up for hearing by this court. Paragraph. Mr. Shuman Kumar Dutt, Learned Senior Advocate, on the next day shall proceed with the depositions insofar as the examination in chief of the plaintiff's witness has happened and the part cross-examination thereof. Thereafter, part cross-examination thereof. This court is informed that the witness of the plaintiff who is on the dock is present, who is on the dock and facing cross-examination is also present today, is present today. He shall also present on the next day. If the preliminary stage of understanding of the matter is over by this court on the next day, as on the existing record and the stage where it is remaining from where this court starts hearing, comma, then the cross-examination shall continue on the next day. Paragraph. The matter shall appear under the heading কিভাবে আছে একটু দেখিনি দাঁড়াও
lot 1
না না টুট ওইসব কিছু না ওটা চেম্বারে হয়ে যাবে suits under the heading suits as it is appearing today on তারিখ কত next with Thursday November 20, 2025. ঠিক আছে রাখো You are there. Give your name. নিশাদ মেডোরার সঙ্গে আছে না with প্রান্তিক মিস্টার প্রান্তিক গড়াই learned advocate.
Item number 48, I appear for the plaintiff, my
I'm for the defendant.
Item number 48, my lords, I appear for the plaintiff, my lords. My lords, we have to file our evidence in chief, my lords.
You have to.
We have to file, my lords. We are
So praying for extension.
Yes, praying for a short extension of 2 weeks, my lords. We will short extension of 2 weeks, my lords. We will file
It's at the stage of witness action. All other formalities have been complied with.
Yes, yes.
It's at
And
the
the
stage of
witness,
witness
naturally, evidence on affidavit
Yes,
shall
yes.
come. Then you will proceed with the cross-examination before commission. I will appoint a commissioner.
Very.
Ashok. Mr.
Pankaj Agarwal, my lords.
Pankaj Agarwal, learned advocate, appearing for the plaintiff submits, appearing for the plaintiff prays for an extension of time to file evidence on affidavit on behalf of the plaintiff. How many plaintiff?
One plaintiff. One plaintiff, one defendant.
Plaintiff. Paragraph. For the ends of justice, the time stands extended till January 22, 2026. Full stop. Copy shall be served upon the learned advocate on record for the defendant. Paragraph. MS
Akanksha Mukherjee, Lordship.
Akanksha
Mukherjee.
Mukherjee, learned advocate with MS
Supesha Banerjee. Yes.
such and such appears for the defendant. Learned advocate. Paragraph. The matter shall appear under the heading suits on February 5, 2025. Thank you. Great to meet.
Item number 49.
Lordship, I'm for the plaintiff. Lordship, on the last occasion, admin.
You've changed the site.
Yes, Your Lordship.
All
For
right.
this item, yes.
Yes.
Yes. Today, witness has not come, Your Lordship.
Who is for the defendant?
Lordship, I am appearing for the defendant bank in this matter.
Witness for what?
Examination in chief, Your Lordship.
It's going on.
Yes, yes. It's not concluded yet.
It's not concluded yet. Because I will ultimately, this part conclusion has to be done, but then it will have to be referred before the commissioner for cross. Not now.
Yes, for cross examination.
After your examination in chief is done in court.
Very well, very well, Your Lordship.
Otherwise, all right. On the prayer of Miss M.S.
Akanksha
Mukherjee, landed advocate appearing for the petitioner, plaintiff, since the examination in chief of the witness of the plaintiff is in progress, but the witness has not come to court today, for continuation of the examination in chief, the matter shall appear under the heading suits on December 18, 2025. Paragraph. MS
Aparajita Ghosh.
Aparajita Ghosh, learned advocate, bracket VC, appears for the defendant with MS
Rupkotha Rai Chaudhary. Rupkotha Rai Chaudhary.
Rupkotha Rai Chaudhary, learned advocate.
Item number 50.
Deeply obliged, Your Lordship.
For the plaintiff, my lord, but an application under order 13A of the Code of Civil Procedure is pending, my lord. It's appearing for the first time.
I appear for the defendant number 2, Lordship. I want to file objection to this application.
Now, there are two defendants in this.
Order 13?
Order 13A of the Code of Civil Procedure.
Oh, summary judgment.
Summary judgment. A claim on account of goods sold and delivered, my lord. In fact, my lord, the defendant number 2 in his written statement had categorically stated that they have no dispute.
All right, let them file an opposition. Ashun. এই নাম্বারটা দিয়ে লেখো ইনরে IAGA
IAGA, my lord, 4 of 25.
IAGA com 4 of 2025. Any dismissal application or something?
Nothing is pending, Lordship.
This is an application filed by the plaintiff praying for a summary judgment. Full stop. There is paragraph, there is no scope for any interim order. Paragraph. Affidavits are called for. You have taken out by master summons or notice of motion?
Notice of motion, my lord.
Affidavits are called for. Paragraph. The defendant, how many?
Two defendants are there.
You are seeking judgments against all?
I'm seeking judgment against defendant number 1.
Defendant number 1?
Defendant number 1.
This is a summary judgment. কি বলেছি পড়ো? Against the defendant number 1 only.
My lord.
Comma, as submitted by Mr.
Pratyush Patwari.
Pratyush Patwari,
Patwari,
learned advocate appearing for the plaintiff. প্যারাগ্রাফ তারপর যা আছে আছে এবার the defendant number 1 shall file affidavit in opposition.
The suit is running undefended, my lord, against the defendant number.
No, he has filed an application summary judgment against defendant number 1.
Defendant number 1.
So defendant number 1 shall file. That is why I have recorded that he has restricted his prayer.
Yes, my lord. And my lord, I should also point out by order dated 10th of January 2023, this honorable court had directed that the suit shall proceed ex parte against this particular defendant, my lord. By order dated 10 January 2023.
Lordship, now I am only contesting the suit. That's why I said I want to file. I need to check this application whether I am only defendant number 2, and I am
It is not claimed against you. So why are you bothered? You contest the suit in your own way. কি বললাম?
So I should also point out, my lord, in prayer B, my lord, the plaintiff has sought.
দেখিয়ে এই অ্যাপ্লিকেশনটা দাও না। ভাই অ্যাপ্লিকেশনটা দিচ্ছ না কেন?
Page number 12, my lord.
দেখি নোটিস অফ মোশন, দেখি নোটিস অফ মোশন।
there's a prayer, Lordship, against defendant number 2. Prayer B.
কি বললাম আসুন? This is an application for and certain further directions upon defendant number 2. তারপর কি লিখেছি পড়ো? As submitted by. Any interim order. Paragraph. No, paragraph. None appears for the defendant number 1. Paragraph. MS
Anjana Banerjee.
Anjana Banerjee, learned counsel, appears for defendant number 2. Defendant number 3 is also not represented. No,
only two defendant, only two.
Full stop. Affidavits are called for. Paragraph. Tarporeর paragraph. The defendants shall file their affidavit in opposition on or before
Lordship, 3 weeks time.
December 23, 2025. Paragraph. Affidavit in reply, if any, shall be filed by January 20, 2025. January 20, 2026. Paragraph. The matter shall appear under the heading এই অ্যাপ্লিকেশন গুলো এখানে আছে সুটের তলায়। Suit in the monthly list of February 2024. 6. In the monthly list of February 2026. আচ্ছা দরকার নেই, একটা আলাদা দিন দিয়ে দাও। On February 12, 2026. February 19, 2026. Suits. Under the heading suits. Full stop. However, comma, the application shall be taken up first.
Deeply obliged.
এটা কত হলো?
My lord, with my lord's permission, my lord, I am appearing on behalf of the plaintiff, my lord, in item number 49, my lord. My lord, praying for any date, my lord, to be fixed for
50 হয়ে গেছে তো? বাস, ওকে, ওভার। 51, দাঁড়ান। লিখুন the suit and connected application, comma, if any. The suit and the connected application. देखिए अब कागजটা देखिए প্লেন্টের এটা কি 50 নম্বর তো 50টা কি হলো হ্যাঁ দেখি 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 একবার কাগজটা দেখি 50-এর কাগজটা 1 সেকেন্ড প্লেনটা দাও একটা পিটিশন দাও ঠিক আছে 51
One, my lord.
51, my lord, AP for the plaintiff.
I am appealing for the income tax department, my lord.
But only the issue here is, my lord, the areas of rent.
What stage?
But stage is, my lord, the principal sum has already been decreed, my lord. It's only the interest aspect.
Interest aspect, they have
take the microphone.
On interest part, they have made an application of GA4 that has been subsequently dismissed by the coordinate bench.
On what ground?
On
Show me the order.
I have no.
But this is the order, my lord.
7th February,
Take
February
the
2025.
Summary judgment for interest.
No, my lord. Summary judgment application was allowed, my lord. I have got back my principal sum. It's only the interest component, my lord, which is left to be determined on evidence.
Why the interest was declined?
But interest was declined, my lord, because a defense was raised on behalf of the defendant that the interest component could not be finalized due to non-cooperation by the plaintiff. But my claim for interest is from the date the rent reasonable certificate was accepted. And a clear calculation was given, my lord. It's only the interest rate, my lord, which possibly this honorable court, my lord, has to decide.
Very well, yes. Decreed জন্য trial pending.
For the
Interest
interest.
জন্য.
My lord, my witness, we had submitted, my lord, we don't want to adduce any evidence, my lord, since we had taken out this application. If your lordship sees this last order, my
What
lord,
is the application they have taken out?
but for payment of interest, which has been dismissed, my lord. That is the order which has been passed in that.
That is the plaintiff's application.
Plaintiff's application, my lord.
So that stands for trial.
That stands for trial, my lord.
Correct.
My lord.
So today, only on account of interest, trial will be held.
Absolutely, my lord.
Your
Grateful.
witness action has been over.
No, my lord, if your lordship kindly sees this order, 26th of March.
Yes,
but
I have.
Since we had taken, but since we had taken out this application, we had submitted, my lord, we don't want to adduce any evidence.
What application you have taken out?
The application for payment of the interest, my lord, which has been dismissed, GA4. The order which your lordship just saw.
The order that I have seen.
Yes, my lord. 7th February.
By which
but I was only claiming interest. But although the interest.
By which the issue of interest stands for trial.
No, my lord, the issue for interest had been sent to trial by the order passed in the order 13A. But after that, my lord, since we are only.
Sir, kindly come to page 7th February order.
My lord. But if my lord kindly sees page 2 of that order, the second paragraph.
Kindly come to the last page, operative part. Therefore, the decree as interest cannot be passed without trial.
My lord.
Accordingly, instant application is dismissed.
My lord.
So the interest component stands for
Relegated
trial.
to trial. My lord.
Would you adduce your, would you produce your witness?
But we would like to produce, my lord, but that order is standing in my way, my lord.
Why? Where it is said that it will
My lord,
not be?
kindly seize order of 26th March once, my lord.
Yes.
But this has been passed after the summary judgment.
So you take out an application.
If your lordship permits me, my lord,
recalling.
then my lord, we go.
What the easiest option ta কেন নাও না ভাই?
When the submissions was made, my lord, before the coordinate bench was not accepted, my lord. That is the only difficulty. I'll take
How
out an
does it
appropriate
matter
application.
to you?
I will take
Record
out an
speed.
appropriate application. my lord.
Plaintiff has filed the suit for a money decree on account of principal and interest. By way of a summary judgment, the principal has been decreed. Principal amount has been decreed.
And that has been paid also, my lord. We have received that.
Which has also been subsequently received by the plaintiff. Paragraph. However, for the interest component, the suit was relegated for trial. Paragraph. 7th February, or when the summary judgment was
My lord,
allowed?
the summary judgment order, my lord, was of 6th February 2023.
2023. So why you are saying when it is pending, 26th March was passed?
No, my lord, after the summary judgment, if your lordship, I don't have the copy. If your lordship kindly sees the summary judgment, I have this, my lord. Kindly sees.
Why 26th March was passed? Tell me. On your prayer?
Yes. My lord, kindly sees the last portion of the summary judgment order, my lord. There also, my lord, the interest part was relegated to the suit. But my lord, we had still taken out an application because we were only claiming interest on the basis of the rent reasonable certificate. But according to us, my lord, there was no evidence required.
এটা প্রয়োজনের বাইরে যেটা দরকার সেটার বাইরে সব করে। Full stop. By an order dated March 26, 2025, it is recorded that the plaintiff on May 10, 2024 submitted before the coordinate bench that it would not produce witness and go for evidence action. Accordingly, the evidence of the plaintiff was closed. Now, since the issue stands for trial, petitioner prays for producing its witness and to prove its claim on account of interest. Accordingly, the plaintiff shall be at liberty to take out necessary application in accordance with law.
Great.
My lord, I am led by Mr. Shoman Bhattacharya. I am led by Mr. Shoman Bhattacharya in this matter.
Mr.
Shoman Bhattacharya.
Are your name?
Ankon Dash. Ankon Dash.
Ankon Dash, learned advocate, led by Mr. Showman Bhattacharya, learned advocate, appears for the defendant. হ্যাঁ একটু দরকার The suit is directed to go out of the list for the time being.
Grateful, my lord.
For the time being.
My lord, I am for the plaintiff, your lordship. My lord, if my lord kindly sees the last order, as per my lord's last order, the plaintiff was supposed to file an affidavit of admission and denial. However, your lordship, the defendant has filed a compilation or served us a compilation of
What an
documents.
extension.
No, your lordship. May I just point it out, your lordship? Defendant has served us with a compilation of documents. Now, my lord, on a perusal of those documents, we found out that those documents are exceeding the documents that they have relied on in the written statement. Now, my lord, the written statement has been filed a long back and they have not taken any leave under the Commercial Courts Act to file those additional documents. Now, my lord, we are at your lordship confusion how to file it, because how to file the affidavit of admission and denial since they have not taken any leave from this honorable court.
My lord, this was done, my lord, way back in the month of perhaps my lord, May or June. Thereafter, my lord, 2 extension was sought for by them for the purpose of filing
Maybe
a
your
written
lordship, but the written
denial.
statement
I
has
do
been
not know,
filed
my lord, what
long
new
long
information
back
has
then.
cropped up. Kindly sees when the my lord
yes,
the documents were exchanged. The long back, my lord, for almost 4-5 months back, my lord, we exchanged the documents.
Lord, Order 11 of the my lord amended code does not permit, my lord, any document which is not there with the written
Written
statement
statement.
to be, my lord, filed without an express leave of the court, and such leave can be obtained only by way of making a proper application. Now they have, my lord, good, bad, indifferent, disclosed 4 or 5 documents which, my lord, was not there in the, my lord, written
So
statement.
you
I have to now
complete
file an affidavit.
can you not complete it without prejudice to your rights and contentions that those documents you don't admit because rather don't take any note of it as they are not part of the written statement?
I can do that, my lord, but it would be, my lord, I would pray, my lord, if lordship records that I can do it in that way, then I will be, my lord, secured in the sense, my lord, these documents in courts of trial cannot be relied upon by them.
My lord, this is
Unless
too premature, my lord. My right for the purpose of taking liberty has been violated.
No question of premature if the law legal statutory provision
my
is there.
right for the purpose
No
of
waiver lies against a statute.
Certainly, my lord, but so far my right for taking a liberty certainly
well.
is there, my
Ashun,
lord.
Ashun,
Tomorrow I can file an application for taking a leave, my lord.
That you come up whatever way you want to come.
That is why, my lord, that particular submission that my right for reliance on those documents is to be shut down. Perhaps, my
Ashun, likhun. Mr. Rajarshi Datta, learned advocate, appears for the plaintiff with
Miss Mayuri Ghosh.
No, she has begun. MS.
Mayuri Ghosh. Mayuri Ghosh.
Learned advocate led by Mr. Rajarshi Datta appears for the plaintiff. They submit that pursuant to the direction of the court, sole defendant.
Yes, sole defendant.
The defendant has disclosed certain documents, disclosed the bunch of documents of which some documents are not at all made the key matter. Polygility, prolygility. Yes, some of Kivalam, of which not made either part of the written statement or referred to in the written statement.
those were referred to, my lord, not part of.
Sir, it is their content.
I'm sorry.
Full stop. Mr. Datta raises an objection that in view of the amended provisions under Order 11, Rule
1, Sub-Rule 4 and Sub-Rule 5.
Order 11, Rule 1. In view of the amended provision of under Order Roman 11, Sub-Rule 1, in view of the Commercial Court Act, কিভাবে বলেছি বলো? Amended in view of the Commercial Court Act, comma, these documents are not permitted to be relied upon by the defendant unless prior leave of court is obtained. Paragraph.
বর্মন মাইলর, দেবজ্যোতি বর্মন।
Mr.
দেবজ্যোতি বর্মন মাইলর।
Devojyoti Bormon, learned advocate, appears for the defendant, has denied and disputed the submissions made on behalf of the plaintiff.
I'm reserving my right, my lord, to seek liberty, my lord.
Huh?
I'm reserving my right to seek liberty, my lord.
You will file an application?
Yes, certainly, my lord.
That's why I'm granting you that
My lord, yes,
liberty.
my lord.
Full stop. Learned advocate submits that he shall take out necessary application shortly. Paragraph. For the ends of justice, leave is granted to the defendant to file necessary application.
But that leave is not necessary, my lord. He is always entitled to file an application. Otherwise, it would be conclude.
In for the ends of justice, leave দরকার নেই। লেখো এটা for the ends of justice কেটে দিন। লিখুন, in view of the above, the defendant shall be at liberty to take out necessary application in accordance with law, but subject to its maintainability. ঠিক আছে। This এটা কি reading আছে?
Timing of issues, my lord.
The matter is directed to go out of the list for the time being.
Well, we'll wait for some time. In the event nothing comes from there, and we will.
That also I will have to advise.
No, I will. Grateful, my lord.
It shows that you are approaching Friday.
Item number 53.
Direction for what? Can you
This is my suit, my lord.
না না তোমায় বলিনি ওদের
আমাদের my lord, my suit.
For the defendant, your lord, one of the defendants.
My suit.
For what direction?
My lord, there were 3 interlocutory applications. I filed an application for attachment before judgment and security.
What is the purpose for appearing under the heading for
My lord, your lordship will
appearing since long?
My lord, I don't know, my lord. Perhaps this was the hearing of the interlocutory application. That is my application for injunction and his application under Section 8 for stay of the suit for transfer to arbitration. That was being heard by the coordinate bench, my lord, and the coordinate bench had fixed a particular date. The matter could not be taken up because your lord.
8 is pending.
8 is pending. 8 was heard at length, but then there was a. So your lordship has to hear it.
It mattered to me.
Your lordship will kindly hear it again. The 8 and my interlocutory, which are GA 1 and 2, kindly take it up on any convenient day.
It needs to appear in the new motion.
Yes, kindly keep it as a new motion.
বারণ করো এখন এদিকে আসতে। হ্যাঁ, তা আপনারা বারণ করেন না কেন? This is not the side meant for you. Oh, sir, stand there.
बाहर आइए।
If you have to ask anything, you ask after 4:30 to the officers. Mr. Krishna Raj Thakkar, learned senior advocate, appears for the plaintiff. Mr. Rudrojit Sarkar, learned advocate, appears for the
Defendant number 1.
defendant number 1. How
2
many?
and 3. 2 and 3.
2 and 3. 2 and 3.
Defendant number 2 and 3.
Yes.
Mr.
Pandey.
KK Pandey. আরে পুরো নামটা বলবে তো। KK Pandey, learned advocate, appears for
Defendant number 1, my lord. He appears
defendant
for
number 1. All affidavits are complete.
Yes, yes.
In section 8, no.
Section 8, I don't want to use
They
an
don't want to
affidavit.
file
The
an
hearings were started.
আসুন।
Section 8, a plaintiff has to take affidavit.
parties informed today that there is an application pending under Section 8 of the Arbitration Act filed by defendant number
2 and 3.
2 and 3.
It's GA2, my lord. Hey.
Full stop. Apart from that, several other interlocutory applications are also pending
It's only one,
on
my lord.
which affidavits are complete.
Yes, only one, my lord. There's only one more, which is my interim order
more than-
39. No,
Apart from that,
there is one.
an injunction application filed by the plaintiff is also pending on which affidavits are complete.
Actually, to बोलना जब सब.
In view of the above, the applications in view of the above, the Section 8 application being GA 2 I की सब लिखे ना IAGA com of 2025 shall appear under the heading new motion on
पहले खत्म होगा ना फिर वन लेंगे.
तारीख को तो आज की दीदी
अब तो नया होगा ना मैडम इसके पास. तू खत्म करेगा फिर वन.
November 26, 2025. Paragraph. The injunction application being IAGA
1
of 2025 is directed to go out of the list for the time being, and the plaintiff shall be at liberty to mention the same depending upon the result of the Section 8 application.
Right. Just one humble request, my lord. If your lordship's board permits, my lord, can I have an earlier date? If your lordship's board permit.
হ্যাঁ লর্ড বি এখন ডাকার দরকার নেই Yes, Mr. Chatterjee, you are appearing for any matter in the Lord B suit. Mr. Chatterjee, the practice I have adopted that
After
5 suits I will keep in the first lot. So I find 2 or 3 has gone out. So automatically you are elevated. It will appear under the lot A or whatever suit heading. It will appear in the list from tomorrow itself, but it will be taken up on next Thursday. After Mr. Dutt's matter.
Yes.
Which is continuing.
Very
The first one.
Yes.
Because otherwise, sir, I will not be able to do justice on the matters. The entire determined list with suit hearing
Takes time.
and I believe, as I have learned from the seniors, that for conducting a hearing of a suit, it is not a slipshod work. It has to be done in its proper way.
Decide someone's right.
That too, I will adapt a practice, sir, that evidences in a commercial matter I will take up on affidavit. I will send for commission. Then after the report comes from the commissioner, hearing will be taken place. Otherwise, it will not be expedited. And so please don't wait for both of you. Both of you.
I will come back on Thursday.
Please.
Application for final disposal. Item number 10.
শোনো আজকে স্যুটগুলো সবকটাই বেরিয়ে গেল না সেটা অন্য কথা দত্ত সাহেবের সুমন দত্ত স্যুটটা রইলো মিস্টার সুমন দত্তর স্যুটটা রইলো, ওটা থার্সডে আসবে, হ্যাঁ ওইটা উপরে থাকবে, ঠিক আছে। তারপরে এখান থেকে আবার 4টে দিয়ে দাও। নেক্সট উইকের জন্য আমি বলছি, এখান থেকে তুলে 4টে দিয়ে দাও, তাহলে মিস্টার দত্ত স্যুট আর 4টে স্যুটে থাকবে। এটা কাল থেকে লিস্টে দিয়ে দাও, তাহলে ওনারা নোটিশ পেয়ে যাবেন সাফিসিয়েন্টলি। নেক্সট, আর একদম প্রথম সিরিয়াল নাম্বার থেকে দেবে, ডাজেন্ট ম্যাটার সিরিয়াল নাম্বার কি আছে, কার 1, কার 7, কার 15 আমার দেখার দরকার নেই, যেমন লিস্টে আছে সেইভাবেই হবে। নেক্সট, দিয়ে লাভ নেই, কেউ নেই তো, চলো না হুল করে ডেকে দাও।
Item number 11. Item number 12. Item number 13. Item number 14. Item number 15. Item number 16. Item number 17. Item number 18. Item number 19. Item number 20.
My lord, I appear in item number 20. This is my application, my lord.
Application for?
My lord, the difficulty is,
Uh-huh.
my lord, difficulty is I am without the brief. My
Passed over.
lordship.
Inform the other side so that next day they are here, it can be taken up.
Grateful.
একটা কাজ করো তো, ওখানে একটা ছোট্ট নোট দেবে, আসবে তো আমার কাছে। On Thursday, in the second half, only quote unquote suit matters shall be taken up. Quote unquote suit matters taken up. And then the list will be called on serially. Then the list will be called on serially. লিখে দাও।
Grateful.
Thank you.
I missed item number 10, but I have heard what has fallen from your
কি
lordship.
দেখি বুঝতে পারছি না।
Item number 10.
দেখেছি কত?
It is item number 20 going on.
হ্যাঁ ঠিক আছে, what is gone is gone. Next, but inform this to the library.
Yes, surely I will do that. I will
Both
do
the
that.
stairs, upstairs and downstairs, that on Thursday those 5 matters suits, those will be called on.
Yes.
As today I have done.
Yes.
The moment those 5 matters is over or collapses, it will
It will
continue
come back
from the
to
list.
the main list. Diploma. I will.
Item number 21. Item number 22.
I appoint you as the special officer to do the work.
I will immediately route it in the group and then I will go and tell.
Yes.
Item number 23. Item number 24. Item number 25. Item number 26. Item number 27. Item number 28. Item number 29. Item number 31. Item number 32. Item number 33. Item number 34. Item number 35. Item number 36. Item number 37. Item number 38. Item number 39. Item number 40. Item number 41. Item number 42.
42, my lord, I appear for the plaintiff. Your lordship, this is my injunction application. Your lordship is hearing order 7 rule 11, which is kept on 18th. Lordship may kindly keep.
Item number 43.
Lord, Mr. Dasgupta is there.
Next.
Item number 44.
Great.
Item number 45. Item number 43.
হয়ে গেছে। চলো দিয়ে go.
Malad has called Milad OCD 20.
Huh? The one you have mentioned? Yes. Yes, Mr. Mitra was there. He has made his submissions. Mr. Ranjanlal Mitra.
Very well.
He has made his submissions.
Very well.